Hey, wait a minute. Councilor Rivera is not in. He's raising his hand, which means I think that somebody needs to promote him. And so is Councilor Cassett Sanchez.
Okay.
And so is Councilor Garcia. So please, yeah.
As the host.
I'm getting it right now. I'm doing it right now. All right, we're good to go.
Okay.
Hey, wait a minute. Councilor Rivera is not in. He's raising his hand, which means I think that somebody needs to promote him. Now we got an echo. All right, are all our committee members here? I count 1, 2, 3, 4, 5. Look at that, we're all here. Fabulous. All right, so.
We do need to wait for the stenographer to be here.
That's kind of a crucial issue. All right. We will hold. Who's working tonight?
It's Linda Vigil.
Okay. Sally, you've got a cool butterfly.
Jen, did she get an invite?
Christine was just forwarding it to her.
Okay. Once she gets on, Councilor Romero Worth, I will hand you over the hosting thing.
Okay, and we're live on YouTube right now.
Yes, ma'am, and the stenographer has just been put in, so I will promote you to host. You are good to go.
All right, thank you. All right, so at a couple minutes past 5 o'clock, I'll call this meeting of the Quality of Life Committee on July 1st, 2020 to order. If we could get a roll call, that'd be great.
Councilor Romero Worth,
I am here.
Councilor Rivera,
Here.
Councilor Villarreal,
Present.
Councilor Cassett Sanchez,
Here.
Councilor Garcia.
Present.
You have a quorum.
Fantastic. If we could approve the agenda, I think there's some changes, right? Jennifer, can you please go over those?
Yes, Madam Chair, members of the committee, we do need to pull off item 6A and item 6B due to them being incomplete or simply not ready.
So we will not be considering items 6A and 6B this evening. Are there other changes from the committee? Motion to approve, if
Move
not?
to approve is amended.
Second.
Okay, if we could have a roll call on that, that'd be great.
Councilor Garcia,
Yes.
Councilor Villarreal,
Yes.
Councilor Rivera,
Yes.
Councilor Cassett Sanchez,
Yes.
and Councilor Romero Worth.
Yes.
Motion passes.
All right, then we will move to the consent agenda. I believe there were some items the committee is interested in discussing. Now would be the time to pull those.
Madam Chair,
Yes, Councilor Villarreal.
I'd like to discuss item D as in dog.
Okay,
That's all I have.
others?
Item F, please.
Other items? Councilor Rivera, Councilor Garcia?
Madam Chair, item E.
All right, and Councilor Garcia, you had one as well?
Yes, Madam Chair, item E as well.
Okay. So with that, do we have a motion to approve the agenda? Have we left anything on there?
Move to approve is amended.
Second.
We had C. All right, if we could get a roll call, that'd be great.
Councilor Villarreal,
Yes.
Councilor Rivera,
Yes.
Councilor Cassett Sanchez,
Yes.
Councilor Garcia,
Yes.
and Councilor Romero Worth.
Thank you, yes.
Okay, item passes.
All right, so then if we can move to approval of the minutes, do we have changes from staff and or the committee? Seeing none, is there a motion to approve?
Move to approve the minutes, Madam Chair.
Is there a second?
Second?
Second,
Second from Counselor Cassett Sanchez. Motion was made by Counselor Garcia. If we could have a roll call on approval of the minutes from June 17th. Thank
Counselor
you.
Garcia,
Yes.
Counselor Cassett Sanchez,
Yes.
Counselor Rivera,
Yes.
Counselor Villarreal,
yes.
Counselor Romero Worth.
Yes.
Motion passes.
All right, thank you. So with that, we will move to the items that we have pulled from the consent agenda. And we will go to item D, and Counselor Villarreal, I think you wanted to discuss that.
Yes, thank you, Madam Chair, and thank you, Mr. Mason, for joining us. I think it would have been helpful to have a memo before this item so that people had some background on this entity, on the coalition. And I'm not quite sure why we're hearing it, other than I'm guessing they're reconstructing this particular coalition, and I was wondering if you could expound upon why we are hearing this item, because it essentially starts off with like the creation of the Regional Coalition of Llano Communities, and that entity already exists. And so I'd like to learn more about why we are hearing this tonight.
Madam Chair and Councilor Villarreal, I believe that Councilor Garcia may have more insight on the participation of the city on this coalition.
Yeah, as Madam Chair, Councilor Villarreal, so this is an updated JPA to an existing JPA that the city of Santa Fe is currently in agreement with. This JPA actually was going through the committee and council process, if I'm not mistaken, in November. It was being carried by former Councilor Peter Ives, and for some reason it disappeared. I was not able to get any clarification onto what happened with it. So it was brought to my attention because I am now the liaison for the city on the Regional Coalition for Llano Communities. And this is something that essentially should have taken place months ago. So we're getting it back in front of the council for reapproval. The Regional Coalition is not being reestablished. Nothing's kind of being reformed. There, in essence, there has been change of leadership within the coalition within the last couple of years. I know that there has been some challenges in the past with the coalition, but the new leadership has worked tirelessly to get the coalition back into good graces with the Department of Energy, who provides a majority of the resources for the coalition. So in a nutshell, that's what this JPA is. It was amended, I think, and I'd have to get the exact dates, but it was amended last year. And so it was requested to be brought forth back to the governing body last year. And it somehow didn't make it through the process. And that's why we're going through the process again.
So what exactly has changed for this particular JPA?
I would have to ask that, so I can get a strike sheet in regards to what has changed from the last one to the new one. I don't know that question, and that's where I can look at past legislation to see why. Like I said, I still don't understand why it was scheduled to be heard, if I'm not mistaken, in an October or November council meeting. It had made its way through the committee process, and then it's got dropped off of a council meeting for some reason, and I still haven't been able to get clarification, but I can get a strike through on what changes are there.
Yeah, I think that would be helpful. I'm just guessing it might be the fiscal agent, but I'm not quite sure. And I also wanted to know if the same members are currently on this body or if some have dropped off. And the other piece that it doesn't entail is that we always, from what I've understood, I've never been the representative on this coalition, but that we have a financial obligation to be part of the coalition. And this particular JPA does not indicate what that amount is. And so if there is a financial obligation, we need the amount, and we also need a FIR and where that funding source would be coming from. all that information is really important. I think in the past, some of us on the council have been skeptical about the role of this entity and what the coalition actually does for our communities in the region and how specifically the city benefits being part of the coalition. In the past, it's been, advocating in Washington, and we never really were given clear indications of what role we have played and what was the mutually beneficial role of being part of it. We've never gotten reports of policy decisions made by the coalition or where we weighed in. And then additionally, in the past, we've had city resolutions indicating our stance on the non-proliferation of weapons, reducing plutonium pit production, environmental justice, accountability, and all of those are stances through city resolutions, but I've never understood how those have had any weight or value based on the coalition's priorities. And so that's always been an issue for me. So those are the things that I feel like are important to understand about the coalition and what stake we have in participating or not participating. And from the past discussions, I want to say it was 10,000, but I can't remember if that was the exact amount. So all of those pieces I'd like to know in the next committee meeting, if we can get those, that would be helpful. And also if there's been ever reports that our representative on this coalition has ever provided for councils, for our council. I've never seen it ever in my time on the council. So it would be helpful if there's things that show why it's important we're part of it and where we actually have a important role to play in influencing policy decisions at LANL and with DOE. That's all I have. Thank you.
Sure. And I definitely can work on getting all of that information, Counselor. I think also what might help is to have the executive director for the coalition participate in future meetings. Given that I'm I think I'm the newest member on the coalition. So I'm still learning in regards to historical actions and the current actions of the committee because it is changing. It's more so changing towards looking at cleanup and how we are working to address the cleanup and that's currently needed in the LANL laboratories. But yes, I agree. I can get all this information for you, and then I'll request that Eric, the executive director, attend not only the future committee meetings, but should it make it to council, make it to the council, he'll be in attendance of that as well.
That would be helpful. Thank you.
Yep.
Okay, other questions on this item?
Madam Chair.
Councilor Rivera.
Kyle, who's the fiscal agent for this board or committee?
I would have to defer to Councilor Garcia for that one.
So Councilor Rivera, the new fiscal sponsor is, I can't remember the name. I'm having a brain flip right now. It's not under, they have a brand new fiscal sponsor within the last year. And that's why we do have the new JPA. Hold on one second. Let me pull that up, Councilor.
All right, Kyle, while we're waiting for that, do we know if the other members have already signed their agreements?
Yes.
So we're the last.
We're one of the last ones to sign, Councilor.
Okay.
And we can include the information that was requested by Councilor Villarreal and Councilor Riviera in the memo for the next committees as well as if it makes it to council. But it would appear in the JPA on page 5 of 7. It lists the fiscal agency as an agreement by the New Mexico Department of Finance and Administration, but I don't see anything more specific.
Well, Councilor Garcia, if you can't find anything immediately, this can wait.
The fiscal sponsor is Chicanos por la Casa, New Mexico.
I assume that's a nonprofit.
Yes. And so Chicanos por la Casa is a national organization, and they're under the New Mexico umbrella.
Can you let us know what page that's on?
It's not in the document, I don't believe.
I didn't see it in the document, and it's Chicanos por la Causa out of Arizona.
Right, yeah, that's the organization, but it's the New Mexico chapter of it.
So if we can get some clarification on that, because usually nonprofits go through a government entity, which has a little stricter accountability on the use of government money for spending. So this sounds like it's a little bit backwards to me. So if we can just clarify that.
Sure.
Okay.
Okay.
And that's all I had, Madam Chair.
Okay, Counselor Cassett Sanchez.
Thank you, Madam Chair. On that point, just as I'm reading on page 5, it said that the board shall enter into a fiscal agent agreement with a member of the coalition. So is this organization a member of the coalition?
No, so actually the fiscal agent is Los Alamos County.
Okay.
Yeah.
So where does this organization come in? The Chicanos por la
So
Casa.
they are the host entity. So you have a fiscal agent, and then you have a programmatic operation side. And so the programmatic side is through the Chicanos por la Causa.
Okay, thank you. Thank you for that clarification. That was all.
Okay, other questions? All right, is there a motion to approve? Is there a motion? Let's put it that way.
Madam Chair, personally, I don't feel like I have enough information. And we're gonna hear this in what committee? Finance and what are the
I don't
next?
know, does anybody know where it's going next?
It is scheduled to go to Public Works on 7/6. No, I apologize.
It's the Finance Committee on July 20th and the governing body on July 29th.
Yeah, actually, I see that now. Finance, July 20th.
Well, personally, I wouldn't recommend it. I'd move it forward without a recommendation if you want to be able to get us additional information.
Second that motion.
Madam Chair, just before we move that to Kyle, are there any time, I know we're already behind on this, but are there any additional time constraints that we need to worry about?
Madam Chair, Councilor Riviera, I don't think there's a hard deadline by any means, but we are trying to show our participation in the coalition if we do want to have a stake at the table to continue that. I think that they've been working with us so far, allowing the attendance of Councilor Garcia, but I think at a certain point that would end and we would no longer be a member and be able to participate in the meeting. So we're trying to get it through, but with reasonable accommodations, and we're trying to get you guys everything that you need to make an educated vote.
Thank you.
All right, so we have a motion from Councilor Villarreal to move this forward without recommendation, second from Councilor Cassett Sanchez. If there's no further discussion, we can go to a roll call vote.
Counselor Villarreal,
Yes.
Counselor Cassett Sanchez,
Yes.
Counselor Rivera,
Yes.
Counselor Garcia,
I'm going to abstain since I'm pushing this through.
Counselor Romero Worth,
Yes.
motion passes.
Madam Chair, you're on mute.
That's helpful. Okay, starting over. We are moving to item E, which is consideration of an ordinance amending section 14-11-4 of the Land Development Code to adopt civil penalty provisions, a civil fine schedule, and civil citation procedures for land use code enforcement actions, and to permit the land use director to order a 1-year waiting period for application for short-term rental permit by a person who has violated the short-term rental ordinance. Just to give everybody background, there were 2 bills introduced to address short-term rental issues in the city. One has been held back for further work after the public comment from the Planning Commission. And this one is moving forward. This is the civil penalty structure to strengthen our enforcement measures. And I think we have both Sally Paez from the City Attorney's Office and Eli Isaacson from Land Use. And I think it might be better, that was a quick thumbnail. I think it would be better if they both dive into this with a little bit more detail, and then we can take questions from the committee if that's okay. So I don't know, Eli or Sally, which one of you wants to lead off?
Sally, do you want to take the lead and maybe talk about the ordinance, and then I can follow up with, the land use perspective on, the need for new tools for enforcement?
Sure. Thank you, Madam Chair, members of the committee. As noted in the brief introduction, this legislation was drafted as a companion bill to the proposed amendments to our short-term rental ordinance. But the bill is actually much broader. It applies to Chapter 14 generally, so that's the entire land use code. So we're amending the existing section 14-11.4, which is all land use code enforcement options. The main thing that's been added is a civil penalty option and a procedure for imposing and collecting and appealing those. But we've also clarified a little bit the existing authority of the land use director to revoke permits and withhold permits. We've added a standard here that says that the land use director can revoke or withhold permits if the applicant or permittee has violated a regulation relating to the granting of the permit, or if in the judgment of the land use director, the public welfare requires that the permit be revoked or withheld. That standard is kind of loosely based on state statute that deals with revocation of business licenses and gives the governing body of a municipality the authority to revoke a business license in sort of similar circumstances. So that's where that standard is loosely based on. It also adds a 1-year waiting period, and this is a brand new subparagraph. The land use director may order a 1-year waiting period for an application for a short-term rental permit by a person who has operated a short-term rental unit in violation of the short-term rental ordinance or failed to pay or report taxes required on the short-term rental unit. And so this again is intended to dovetail with the amendments that strengthen the requirements to make sure that all rentals are permitted and paying taxes. This is sort of some of the main goals of our general changes to our short-term rental program. Then the main change is additional information in paragraph C. So there is a paragraph C entitled civil penalties right now, but it really doesn't include any real substance. It just says that a penalty fee may be assessed for construction without a proper permit in accordance with a schedule adopted by resolution of the governing body. And so it's limited right now to a construction permit, and there is, to my knowledge, no resolution of the governing body that sets a penalty fee schedule at this time. So it's really not a provision that's been in use, and it is currently limited to construction permits. So this would really expand the civil fine option to any violation of the land use code, and it would definitely cover rental of a short-term rental unit without a permit or registration or a failure to pay taxes on those units, but it would also apply to most other violations of the land use code. And another thing here, it also includes a provision that says misrepresentation of fact on an application submitted to the land use department, which could be useful in a lot of contexts, but in terms of the short-term rental implication here, our applications right now require folks to affirm when they apply for a permit that they're violating, or that they're operating the unit in compliance with the law and that they're not violating any restrictive covenants that apply on their property. So this is kind of a companion to the provision that says, you know, you're not allowed to rent a short-term rental unit if you have a restrictive covenant that precludes it, a private covenant. And this provision would expressly allow fines in that instance, in addition to revocation of a permit if somebody was to do that. So that's one of the concerns of the short-term rental legislation that are hopefully going to be addressed on a slightly separate time schedule. So this basically sets up a civil fine schedule. It's for violations that can be remedied right away. Additional days of violation would be a separate violation, and it sets up kind of a ratcheted fine schedule. So the first violation would be $100, the second violation would be $250, and subsequent violations would be $500, and that's within a 36-month period. So this would require tracking by the land use department of previous violations by the same permittee or owner. And let's see, under, I believe the New Mexico Constitution, we're not allowed to impose a fine greater than $500. And so this is based, the $500 is kind of the upper limit for one violation, what the city is allowed to impose, but that's for third and subsequent violations. So we've got a process for delivering a civil citation to the violator. It explains what the contents of the civil citation must be to provide notice. And the notice must instruct the violator that they have 15 days to pay or request a hearing. It's like basically an appeal hearing before a hearing officer. The ordinance then sets up an administrative hearing process before a hearing officer who's been appointed by the city manager. And that process is kind of loosely based on our uniform traffic ordinance. So we've got a whole separate document outside of our normal municipal code that is our entire traffic ordinance. And it sets up for parking fines, a process for requesting to have your parking fine kind of appeal to a hearing officer. You must submit the fine for the appeal. So it's very loosely based. Actually, the rest of that process is loosely based on what we right now do with a parking fine, because we're really viewing this as a similar civil penalty typed enforcement option. I think that's basically the overview. I don't know if that's too much or too little, but I'll hand it over to Eli for any additional thoughts, and then we can answer questions.
Great, thank you, Sally.
Thank you, Chair Romero Worth, fellow councilors of the committee. As Sally mentioned, you know, enforcement has been an ongoing challenge, especially with STRs for almost as long as the program has been in effect. And I think a lot of that has to do with we don't have good tools to really enforce short-term rentals in the city. Our process now is a process that's sort of was designed to address property maintenance issues, whether it be weeds, junk cars, other types of issues. And the nature of the types of violations we get with short-term rentals just doesn't fit that enforcement mechanism very well. To my knowledge, we have not taken anyone to court over STRs, which is our real only that's our only real teeth in our current system. And so by enabling the civil penalties, we can be much more responsive and reactive to the issues that we're seeing related to the operation of short-term rentals in the city of Santa Fe. So that's my motivation for adding this in with the companion bill that we are still working on, is to really be able to hold people's feet to the fire and get the type of compliance we're looking for in terms of short-term rentals.
Great, thank you for that, Director Isaacson. If we could go to Councilor Rivera, I believe you had pulled this on, and then we'll move from there to Councilor Garcia and then to the other committee members.
Thank you, Madam Chair. I don't know if this is for Eli or for Sally, but maybe for Eli, since you wrote the cover memo, but on the executive summary, and the Planning Commission brought this up as well, but that second to last sentence where it says, additionally, the ordinance will prospectively limit the number of short-term rental permits to one per natural person. Can you explain what that means?
Sure. So, and I think Sally, if you don't mind, I think it'd be great if you would chime in, but Madam Chair, Councilor Rivera, one per natural person is a provision that we've added to limit the number of short-term rental permits or licenses that can be obtained to one per person. And so we are trying to limit the proliferation of these large short-term rental industries or sort of speculation around the short-term rental market. And this was a provision we included to hopefully limit that to some degree. This, there's been some questions as to whether this would be in conflict to ownership under an LLC or other similar entity. It would not be in conflict to that. Just someone who's a registered member of the LLC would have to be the permit holder for that short-term rental unit, and that person would be limited to one short-term rental permit or registration in the city.
If I can jump in here, so that provision is not part of this bill, correct?
That is correct. That is included in.
So I'd like to keep us focused on this bill because we don't have the other bill in front of us. And I know that's a little confusing because you have memos that address the other bill. This one, that other bill, is coming down the pipe at a future date. So I'd like to keep our questions just to this one that is in front of us with regard to civil penalties, as Sally has explained, for violations of the land use code generally, and then the specific provisions that relate to short-term rentals.
And thank you, Madam Chair. I think there was another memo, a sort of a memo a memo to be placed sort of on top of the other memo that described sort of how we've changed course a bit and separated the two. I'm not sure if you received that, Councilor Rivera, but that memo kind of described where we are in the process now and the difference between the two bills.
I did receive that one, but this is the one that came with the bill, so I didn't realize there was another bill coming down.
Yeah, so I think for simplicity and not to confuse folks, what we have in front of us tonight is only the bill that provides for civil penalties. We will see the other bill at another place in time, and we'll have full opportunity to go through the provisions of that, but that is not what is in front of us tonight.
Okay, fair enough. So then, Eli, just do we have the staff to enforce the new ordinance and these new fines, I guess?
Thank you, Madam Chair, Councilor Rivera. We are short a couple positions in the what we are calling code compliance. We've had some retirements over the past 12 months, and we've had some vacant positions related to some positions that have remained vacant related to those positions and retirements. I can say that I think the civil penalties option will allow us to be more effective with our enforcement with the staff that we do have. There's a lot less, we no longer have to build a case, so to speak, as we used to have to do, but now we can sort of enforce the rules on the spot and hopefully get compliance on these issues much faster. It would hopefully involve less staff time to implement and enforce.
So how many people do you have that are, is all your staff, do they do multiple jobs, or do you have a specific amount that just looks at short-term rentals?
Thank you for the question, Councilor Rivera. So we have, let's see, we had a recent retirement just last week. So I think now we have 5 individuals in our code compliance division, all of whom are capable of enforcing the short-term rental ordinance. We have 2 people that we are dedicating to short-term rentals at the moment. One is primarily focused on the permitting and licensing process, and another individual who is taking on a large bulk of
Did he freeze? or
Director
is it
Isaacson,
just-
you froze up real
Discussions,
bad.
Part other folks.
You froze there, Eli, for a little bit.
Oh, I'm sorry. It's saying my internet connection is unstable. I'm going to stop my video. But just sorry about that. Just to repeat myself, we have 5 in code compliance, 2 that are more focused on short-term rentals, but the whole division can work on short-term rental related issues and enforcement of the ordinance.
All right, so part of this talked about if a short-term rental has some kind of police activity, so let's say a party, for example, or making too much noise and the police are called, police get there, tell them to quiet down. How does that then get translated over to your department or your division so that the case starts to be built?
Thank you for the question, Councilor Rivera. So I think, in looking at past reports or, some of the past enforcement stuff that has come out of short-term rentals, I think that connection between police and the code compliance staff and land use has always been a challenge. And I think there's an opportunity to strengthen that. In terms of this specific scenario, I'm not exactly sure how we would handle that. Hopefully that complaint would come both to police and to the short-term rental office, where the short-term rental compliance officer could then follow up with police and follow up with any necessary action. But that is certainly an area where we could strengthen the connection between those 2 departments.
If I can, I'd like to have Sally weigh in on that question, please.
Thank you, Madam Chair, Councilor Rivera. It's a good question. I think the thing to kind of keep in mind about the land use enforcement provisions in the code is that they are separate and in addition to the criminal process. So we can still file a criminal citation for criminal action in municipal court. Police can certainly file a complaint on anything that rises to the level of another violation of the criminal laws. I think in a situation with like a party or something, that might not be the kind of thing that would be a civil fine under the code. But it leaves discretion for that. So I would picture that might be something that would be more of a potentially a police matter, potentially a criminal matter if there's a crime involved. But to the extent that we have folks, I think with civil penalties, we're mostly focused on people who are renting without permits, who are not paying their fine or their taxes to the city, their lodger's tax and their GRT taxes, when we can demonstrate that they're not doing those things. When they're but if we can prove that they've rented more than once in a 7-day period, which is against the rules. So I think it's a lot more of those kind of things. In terms of keeping the peace, disorderly conduct, noise violations, things of that nature, it would probably still be a police matter. That said, we're allowed to do both. I mean, the way that the code's written, we can, and I don't want to put Michael Prince on the spot. I see he's here with his video muted as well. And he's the one in the city attorney's office who's primarily focused on code compliance issues. I do much more of the stuff where people are behaving, and he handles the ones that aren't. But we coordinate with our one prosecutor in municipal court as well. So we have one criminal prosecutor in municipal court, and he's a member of our city attorney's office team. And so through that mechanism, we do have the ability within our office to kind of cross-pollinate and communicate. So when we have a code violation that also becomes a court matter, we do have that connection between Mike and Kyle. And so we can do these tracks kind of separately. So it would sort of depend on the nature of the violation and which of our enforcement tools we wanted to pursue.
But it does call for repeat offenders, I guess, to then be kind of put on the spot if within a 6-month period they receive multiple police calls or fire calls, issues like that. So how does that get communicated between land use and police so that police doesn't go out 3 times and then land use goes out once and land use just figures it's a first-time offense?
Thank you, Chair Romero-Worth and Councilor Rivera. I think that this ratcheted civil fine schedule would only apply to second violations that resulted in a civil fine. So it would have to be a fine issued by the land use department to get that second violation. So in a situation, for example, where we can prove that we have somebody who didn't pay their lodger's tax on a rental in January, and we were able to demonstrate that and charge them a civil penalty, and that was either not challenged or upheld. And then again in April, we again are able to look at our records that we're able to get through host compliance or wherever else and show that again they failed to pay their lodger's tax to the city. Then we would for sure have a second violation that resulted in a civil penalty. So it wouldn't apply to violations that resulted in a criminal action or a warning from the police or other types of enforcement activities. It would only apply to a second violation that's resulting in a civil fine.
All right, and then I don't know if it's Eli or Sally, but who's gonna keep track of all the online platforms to make sure compliance is done?
So thank you, Madam Chair. Councilor Rivera, thanks for the question. So we have a contract with a group called Host Compliance that Sally just referenced. They're the ones who track our registered list against suspected operators in the city and give us a list every 2 weeks, I believe, an updated list every 2 weeks of possible folks operating without the proper registrations and licenses here in the city. So that's who is doing that. And they're actually much better than our previous vendor, Harmari. These guys are working much better, and they have an API that works with Energov. And so that's how we're able to give them our latest and greatest data, and they're able to use that against them scraping the platforms and looking for unregistered hosts.
And are they able to track multiple platforms? I thought at one point they had success with maybe one or two, but not with all the ones out there.
This group is very comprehensive in their tracking. They are tracking, I would say, the largest 7 or 8 listing sites out there. And between those 7 or 8 sites, I think we're probably getting, around a 95% coverage, if not better.
And this will allow us to issue citations to the owners of those properties?
I think I'd like Sally to weigh in on this, but I think the citations, it's not entirely, Sally, you may want to chime in. Do the citations go to the owner or to the permit holder? Because they may not necessarily always be the same.
It would be a person who rents. I mean, it depends on the violation, but usually it would be a person who rents in violation of the ordinance. So they wouldn't be a permit holder if they're renting without a permit. So in that case, it would be the owner or operator who's advertising it, listing it, and renting it out. If it was a failure to pay taxes by a permitted short-term rental unit, the requirement to pay those taxes, it runs with the permit holder. So that person would be the person on the hook. So it would depend a little bit in terms of the regulations put burdens on a couple of different actors. And so it would depend on who was violating what, I think. But usually it would be the owner or permit holder.
Okay, and then is this done through your office, Eli, or is it, I know at one point it was under Randy at the convention center. So is working with this company, the contract, has that gone over to you?
The contract with Host Compliance is held or is managed by Land Use.
I'm sorry, managed by Land Use?
Land Use, correct.
Okay, thank you. That's all I have for now, Madam Chair. Thank you.
Before I go to Councilor Garcia, the other thing you should know is to the extent that the short-term rental property begins to create a nuisance for the neighborhood, that's under the next bill that we're going to be talking about. So these new tools, both with regard to nuisance and then the violations of the land use code, I think will do a lot to bring the city up in its ability to enforce the rules. So Councilor Garcia, you had your hand up next. You pulled this item.
Thank you, Madam Chair. I think it's fantastic. We're really looking at enforcement now. I think that's one big thing that the community's been really pushing the city to get the ball on is enforcement. I think that probably has been one of the biggest concerns of community members is we have the rules, but we're not enforcing them. And now that we're developing these tools, hopefully we can enforce the rules. Do you know how many short-term rentals do we currently have licensed?
Thank you, Madam Chair, Councilor Garcia. We are still, there's some tracking that we're doing in EnerGov, making sure that every permit is statused correctly. But I think right now, roughly, we have about 825 permitted residential short-term rental units in the city. Our cap by resolution is 1,000. So we're working with anywhere from, I would say, 175, 150 remaining permits available.
Okay. Because I think the last stats I last saw, there was, roughly 1,400 in operation in Santa Fe. So that's still, 500 plus out of compliance. So I like that there's a cap at 1,000, but my question is, are we going to offer a grace period for these folks? Because I do see a rush for folks to become in compliance now that there's going to be some more teeth for enforcement. So is there going to be any type of amnesty or grace period where we will allow folks that might be operating out of compliance to get permitted, get their house in order, so to speak, that way they don't face a fine?
Madam Chair, Councilor Garcia, an amnesty period or a grace period has not been discussed. What we have discussed is a waiting list for those who apply after the 1,000 cap is reached. And that waiting list will be organized by those on a first come, first served basis. Every year we have, this year I think was somewhat unique because of the COVID situation, but every year we have, a significant number of permit holders that do not renew on time. And therefore their permits expire. And so those open slots of expired permits would be available to those on the waiting list. So that's how that situation would be handled as it is currently contemplated.
Okay, but my question was more so around grace period, because I definitely would like to see some type of grace period for those folks that are operating out of compliance to be able to get in compliance, whether it be 60 days. I think I would use your expertise in regards to how long it takes to go through the process, because I think, once folks realize we are going to start enforcement and hold those out of compliance accountable, we want to give folks an opportunity to be in compliance. So how long does it usually take for somebody to go through the approval process? Is it 45 days, 60 days? What do you feel would be a fair time period?
Madam Chair, Councilor Garcia, I think a new application can reasonably be either approved or denied within 30 days of receiving the application. We are now taking applications online, which is speeding up, and we are also taking payment online, so that is speeding up the process. So 30 days is probably actually longer than it would take, but would be sort of the outside range on reviewing and approving an application. I think to Councilor Romero-Worth's earlier point, we may be veering, some of these questions may be veering out of the realm of the civil penalties bill into the other bill that will be considered at a later date. The other bill that is not before us tonight is the bill that contemplates the cap and how we manage that cap moving forward. And I think your questions tonight, Councilor Garcia, are more, or maybe more relevant to, establishing the cap and how we manage that cap than the civil penalties bill that's in front of us now.
I respectfully disagree, Mr. Isaacson. I think more so what I'm looking at is having this proposed bill not take effect for 35, 45 days. That way it gives folks an amnesty period to get registered. I'm not looking at changing the cap. What I'm looking at is giving folks an opportunity to get in compliance. So I'm not referring to the second piece of legislation. So I would definitely like for us to look at setting up a time frame when this shall take effect, so to speak.
Apologies, Councilor Garcia, I misunderstood your question. I think that we can definitely look at an effective date for this provision, should it move forward, and give people in the community some awareness of the changing rules and changes to our enforcement, such that they may be able to have ample time to come into compliance.
Right. So okay. Thank you. I appreciate that.
Madam Chair, on that point, just to clarify from Councilor Garcia, are you talking about people that haven't yet applied for a permit or never have applied for a permit, or people that know that we have a permitting process and just hadn't updated their information?
I'm talking about the whole gamut, both. Anybody that is currently operating short-term rental without a permit. That way it allows those folks to understand that we are giving you an opportunity. This is their warning period, so to speak, to get their permit and get their house in order. Because if it's not, and we find you out of compliance, that's when you're going to start facing the penalties and see the fines impacting you. And so whether it's you had a current permit, because if your current permit it expires, you're still out of compliance, so to speak.
Right.
And I think that's where it allows those folks that are current permit holders to maybe look at their permit, look at the dates, make sure their house is in order, but also those folks operating out of compliance to get their house in order. And then we can look at enforcement.
I hear you about that. I think the one thing that maybe Director Isaacson can explain is that we actually did have a grace period that allowed permit holders to update their permits. Can you talk a little bit about that? Because we extended it in a pretty big way. So in my opinion, it's more like the people that haven't done anything to actually admit that they have a short-term rental versus the individuals that have been permitted that need to update theirs. And can you explain what was done recently?
Thank you, Madam Chair, Councilor Villarreal. So the process, we start taking renewals. We take applications all year round throughout the year. The renewals start January 1. The permits run for the calendar year. We start taking renewals January 1. The renewal period without penalty extends to March 15th. After which you have a 1-month grace period to renew your license with a $100 fine associated with it. This year, because of everything that was going on with COVID and the pandemic, we extended that grace period an additional month to May 15th. After which, if existing permit holders did not renew by May 15th, their permits were therefore expired and would be required to apply for a new permit. And that was the process that I alluded to earlier, as to how new places within that 1,000 cap would become available to those on the waiting list. It would be those who failed to renew within the required time, their permits become expired, and those slots would then open up to those on the waiting list. So to your point, Councilor Villarreal, I do think we have given people notice. We've sent out multiple letters informing people of the original April 15th deadline. We also sent out letters to folks informing them of the extension. We also did a press release to that effect, and tried to get the word out, so to speak, as to the upcoming renewal deadline and the extension of that deadline.
Thank you.
But on that point, that there wasn't this new elevated fine and penalty structure in place. So notice was given prior to, okay, you could face penalties, but there was, as I said, somebody said earlier, that those penalties were pretty vague. That we didn't give descriptive information on what it looked like. And I think we need to, once again, we have to have folks be re-informed that, look, this is the new law that we're having, because we notified you in the past under the past rules. These are the new rules. This is your last get out of jail free card, so to speak, because I think you will see those numbers jump once folks realize that they're going to be in compliance. They're going to get fined for being out of compliance. So that's where, like I said, I'm willing to look at, but I think that's something we need to implement, is a minimum 30 days for this to take effect when it pass. That way the community knows that they have to be and have their license, or else they're going to face a fine.
To your point, Councilor Garcia, thank you. As these proposed amendments have been advertised for public process and public comment, we have seen a rise in the number of people applying for new permits. So I think that in many ways, the forewarning that you're referring to has taken place, and we're starting to see more and more people interested in coming into compliance with our rules, which I think is what we'd all like to see.
Right, and I think that once we, get further down the path with this, and should it pass, the broader public is going to be aware as well. The folks that are really keeping a close eye on this are the folks that operate in this realm of business. Some folks, they might have the mindset, well, they haven't enforced it in the past, so I don't care. We'll see what happens. But then once, should this pass, I think you will see still that spike continue to move up. My next question is, in regards to businesses that are operating out of compliance, what is usually a typical fee or a fine that a business may see?
Thank you, Madam Chair, Councilor Garcia. So we don't have a way of fining anyone right now. And I think that that's the challenge that we have. So we can issue a notice of violation if they continue to operate, and we continue to give them notices of violation. They eventually can be cited into municipal court, where the judge can issue a fine. Sally, I think you may have some insights into the limitations.
Before we move to Sally, I just want to clarify my question. I'm talking about business in general. So whether it's an ice cream shop, a tire shop, any type of business in Santa Fe that is operating without a business license, what is a typical fine that they might incur?
Thank you, Chair Romero Worth, Councilor Garcia. I'm not sure that there's a mechanism currently in our laws for us to impose a civil fine for operating a business without a license. We have criminal, there are criminal remedies, and I would have to review. I mean, the general jurisdiction of our municipal court is up to $500 for a criminal fine, and that's usually the tool that we've got right now. So if they're violating the law, it could be up to $500 and jail time of up to 6 months. But I haven't seen a civil penalty provision anywhere within our laws, and I don't think we're using one. So it's only a criminal fine that we would have right now that could not exceed $500 for a single violation.
Great, thank you. Thank you, Sally. And that leads me to my next point of why are we not following our current policies and keeping it within the criminal statute, and we're moving towards a civil statute?
Thank you, Chair Romero Worth and Councilor Garcia, members of the committee. The issue, I think, with our current rules primarily is that in order to go to municipal court, there are added procedural safeguards to which the defendant is entitled. So we would have to go through a process of more carefully collecting a higher amount of evidence in order to prove beyond a reasonable doubt a violation. And it's very cumbersome to go through the whole court process. It becomes kind of out of the hands of the land use department. It becomes something that has to go through the prosecutor, has to go through the judge. It requires criminal hearings. And we can certainly do that, but it's a very cumbersome and resource intensive process. And so it's something that I don't think we've really had or dedicated the necessary resources to be able to do that effectively. And I think in terms of our land use code enforcement officers in the past, they haven't necessarily had adequate procedures in place for really gathering the kind of evidence that would be necessary. So you would need witnesses, a neighbor who saw something, and is that good enough? Is it proof beyond a reasonable doubt? What other evidence do we have? And do we have the prosecutor to take it through the court system? So it's certainly an option, and it will remain an option, but it is a very resource intensive process, in part due to the standard of proof that we have to meet and the criminal due process protections that we would have to afford any violators. And something like a parking ticket requires a lot less steps. So I think that's why we're adding a tool. We're not removing a tool, but we're adding one that hopefully will have the resources to more easily implement.
So what follow up to that is, given there is this fine structure, and the determination to find somebody's got to have evidence. Wouldn't that be the same evidence for a criminal statute? So if we use the web scraping service, for example, that would be evidence there in itself, or any other evidence that would be used to give the criminal penalty, the civil fine. So I'm just confused. Why would evidence be good enough for a civil fine versus a criminal fine? To me, they're one and the same.
Thank you, Councilor Garcia, for that follow-up question. I guess the difference is really the standard of proof, which means in criminal court, it has to be beyond a reasonable doubt, which is there's nobody else that could have done this, and we have really good, it's got to be a very strong case. When we're in the civil realm, the standard of proof is the preponderance of the evidence, which is just a funny way of saying more likely than not, we're pretty sure that you did violate it. More likely than not, we can demonstrate. So it's 51% instead of, I don't know what the percent is for beyond a reasonable doubt, but it's much closer to 100%. So it's not so much it's the strength of the evidence and who we have to show it to. Do we have to show it to a judge, or can we do it in-house? And what is the level of process that we have to go through to get to that point? So it is hopefully the same evidence. We are getting a lot better information now through host compliance. So regardless of which tools we're pursuing, it's a much better form of evidence, a great source of information that we didn't have before. So that will definitely help regardless of which standard we're trying to meet and which type of fine we might try to impose.
Okay. And so what I'm hearing is that the evidence, should it be heard in front of a hearing officer versus a judge, would have to be much lower than going in front of a judge.
Yeah, that's a good summary.
Okay. With that being said, and I do anticipate folks, protesting these fines, how many additional hearing officers do you anticipate us needing?
Thank you, Councilor Garcia. That's a good follow-up question. It's something that we haven't really looked at. We did draft this legislation before the financial crisis, before the COVID pandemic. I know that it's something that the city attorney has been looking into, whether we might do more of a hearing officer pool or how we might do that, because we do have a lot of other situations where we do have hearing officers and they would have to be on contract. We'll have to ask Mike on the next agenda item about what finally made it into that draft in terms of whether there's a hearing officer process there, but we do use them for liquor license hearings. We do use them for cannabis violations. We have a process for that. We use them for parking violations. We use them, and our code actually includes a few other areas where folks can appeal to a hearing officer: plastic bag ordinance, alarm violations. I did a search and we've got kind of a variety of things. And so, that's something that we could look at. I did review, Albuquerque has a separate hearing officer ordinance. That's a much more structured office of hearing officers. I feel as a smaller municipality, I think our original sort of suggestion was that we would do it on a more ad hoc basis and contract out. So I think it would really depend, you know, by providing a right to appeal to a hearing officer, obviously we need to provide a hearing officer. And if we get to the point where we don't have sufficient contracts and we're not paying those folks, and then we might not be able to hold those contracts, we're not going to be able to issue the civil fines. I mean, so I'm not sure exactly what that looks like under our current budget and our current finances. I think it's worth noting that in the draft for this Chapter 14 civil penalties bill, it does say that this money, if for these fines, would be retained for enforcement. So hopefully that's a source of revenue. So to the extent that we do need to impose civil fines and collect fines, then we can use those fines to contract these hearing officers, since it's all part of that enforcement process. So in a way, it certainly hopefully would support itself to at least some degree, but it just depends how many folks we're actually citing and how many of them appeal. And I think it's a little bit uncertain right now.
Right. No, and I appreciate that. I think you hit the nail on the head in the sense it would pay for itself, but we still need to have this, so to speak, startup funds to hire these initial hearing officers. And I'd like to know where we anticipate having these officers come from when we're on a hiring freeze. Because I think having a hearing officer hear these instead of a judge is, you know, better. I agree with that. You know, that's kind of why I wanted, you know, when we did the mask ordinance, for those offenders to go in front of a hearing officer, because they see less fines. They don't have to pay court fees. They don't have to go through that criminal process, whereas a hearing officer, it's a completely different process. I guess the follow-up to that is we need to have that in place, though, because we can't say we're going to have a hearing officer, but then not know how we're going to pay for it. So I'd like for us to have that determined and how we're going to work that out as this moves forward. One thing I'd want to clarify, Ms. Pius, because you brought something that perked my ears. The 7-day rental is not currently in effect, right? That's part of the sister bill that hasn't been approved, because there's not currently a time limit, correct?
Thank you, Councilor Garcia, members of the committee. That actually is in the current legislation. It's in the current general provisions, and it says that we're just carrying over. General provisions, unless otherwise stated, the following general provisions apply to short-term rental units. Little number 1, it's the first one on here. No more than 1 rental is allowed within a 7 consecutive day period. So that is existing in the current ordinance.
Okay, and the other reason why I wanted that clarification is because I know we've got a lot of communication from constituents saying they didn't like that portion, but if it's still in the existing, it's good to be able to pass that along to them.
It's existing. I might add that in terms of enforcement, on the enforcement topic, it has been a very difficult area to enforce, because that's really one of the things that in the past we haven't had very good information. It's more along the lines of where a neighbor would call and say, well, I saw a Texas truck there on Monday and I saw an Arizona truck there on Friday, and you guys need to come out and do something about this. And that kind of information is usually not enough to prove a criminal case, you know, in municipal court. As we talked about the levels of proof, you know, you could bring that person in and testify to that in front of the judge, and maybe the judge would find that sufficient. But we didn't have good information. Now, hopefully we will have better information to try and enforce that provision. But within our existing ordinance, that has been an area that's been very difficult to obtain adequate information to where we could really bring like a criminal case.
Okay, thank you, Ms. Pius, and sorry, Madam Chair, for not keeping to this bill. I just, it popped up and I just wanted quick clarification. Last thing is, in the fine fee structure, I see the 3 different levels: $100, $250, $500. I guess why was the decision made to not potentially not allow this person to even get a permit after so many fines being implemented to them? Because I think, you know, living by the 3 strikes you're out rule should apply here. You know, 2 fines, you got it. Your second fine is your last opportunity. you get heard with the third offense, you have no opportunity to operate for a certain period of time. So I didn't know if maybe you or the bill sponsors would be able to clarify on that.
Would you like me to chime in, Madam Chair, or Eli?
Yes,
Yeah,
please.
So I would
Madam
just,
Chair, Councilor Garcia, I think one of the things that is in there is the really clarifying the land use director's ability to revoke permits. And I think that that would be sort of fall in line with your idea of 3 strikes you're out, right? Where after, if you've received the $500 penalty, you've been a sort of a habitual, offender of the rules, the land use director would then have the ability to revoke your permit. And then, as we talked about earlier, if we're at a situation where the 1,000 permit limit is reached, in all essence, you are sort of at the end of the waiting list, waiting to reapply. And I think that eventuality is enough to get people to really toe the line, not risk the enjoyment of their short-term rental permit moving forward.
And I understand that, there is that option, at the discretion of the land use director, but I think it should be part of the penalty structure, that you incur so many penalties, then you do not have you are giving up your right to operate this business. And I think that should be part of the structure as well. Or else we're just going to have folks just keep getting fines and fines and fines, and they don't care. And in a business where a rental can be upwards of $1,000 a night, they're going to say, I don't really care. Fine me, because I'm still making money. And so I think we need to hold people accountable. And if they are out of compliance at a certain point, we not allow them to operate these businesses. I think that's all I have at the moment, Madam Chair. Thank you.
Okay, other questions from the committee? Okay, I would just note a couple of things. If we have 1,400 people out of compliance, we are not going to be able to give all of those folks the ability to come into compliance, because as we stated earlier in the other bill, there's a cap of 1,000. So just want to point that out. And I think the 1 in 7 days rent at one rental every 7 days. The folks that are complaining about that are the folks in the business district. I don't think folks in the residential areas are complaining about that provision, because again, our problem, one of the reasons why we're bringing forth this bill to provide another tool, and one of the reasons there's a companion bill coming, is the problems that we've seen in the residential areas where people don't have neighborhoods anymore. They have short-term rentals with people coming and going. So these are some of the things that we're trying to address.
On that point, Madam Chair.
Yeah, go ahead, Councilor.
I've heard that argument, the more people renting, more traffic, but I don't necessarily agree with that, because let's for example, use myself. I go to the grocery store every day, okay? In and out, in and out, in and out. Whereas if it was a visitor renting a short-term rental and they're going in and out every day, it's the same amount of traffic. I think the challenge is having folks understand that there is going to be that traffic per household. And unless it is multiple families and multiple cars, which I think this sister bill addresses, but so I think the traffic is going to be there, whether it's a permanent resident, long-term rental, short-term rental, that traffic is going to be there.
Okay, thank you, Councilor Garcia. The only other thing I'd throw out there is, the folks that haven't been in compliance for however long they haven't been in compliance, we are losing revenue because they're not playing by the rules. And I don't know that we need to, be giving them extra time to come into compliance when we've been losing revenue from them for as long as we have. And to the point that was made earlier, I think we, the fact that this bill is moving through the process right now is drawing attention that we are getting serious about this. We're adding to our tool basket, our tool, whatever it is we have. And that'll be, that's sort of sufficient notice for people to realize we're getting serious. Is there a motion to approve this bill?
Madam Chair, before you take a motion,
Councilor
I
Rivera?
know as counselors, we're supposed to be perfect, but I wanted to apologize to Sally and Eli because some of the line of questioning that I had was in regard to the nuisance ordinance and not this ordinance. So I confused myself, so wanted to make that clear and apologize to staff. So thank you.
Thank you, Counselor. I think it's cool you're hearing them both tonight because they are very related. And so I think that's very helpful and they do raise a lot of the same issues. So I think it's all good discussion on both matters.
Thank you for being nice, Sally.
That's true. They're very complementary in terms of the city's ability to take care of these kind of problems.
And they both have these are both long-term problems that I think we are, I'm excited that we are getting something moving to deal with them. So anyway, a motion would be wonderful.
I'd like to move to approve.
Second.
All right, so we have a motion by Councilor Villarreal. We have a second by Councilor Cassett Sanchez. If there's no more conversation, I would like to go to a roll call. We have a lot in front of us still this evening.
Counselor Villarreal,
Yes.
Counselor Cassett Sanchez,
Yes.
Counselor Garcia,
Yes.
Counselor Rivera,
Yes.
and Counselor Romero Worth.
Yes.
Motion passes.
Thank you. Good night, everybody.
All right, thanks, Sally. All right, with that, we will move to our next bill. Sorry, I've got to go back to my, which is item F, and it's an ordinance amending section 10-9. And this relates to, we call this fondly the nuisance bill. And I'm getting an echo here, sorry. And I think I will let Jennifer, are you gonna talk about this, or Mike? Who's gonna lead here?
I'm happy to do. Sorry, there is an echo. I'm happy to do the introduction and then I'm happy to take any questions. We did include a policy brief that, was attempting to kind of justify a lot of the changes. But I think overall, the old nuisance bill was really vague. It was very unenforceable. It required a lot for the city and it ended up having to go to court and that was very difficult. And so similarly to the chapter 14 civil penalties, we are adding a civil penalty, but the main thing is really providing a very clear process to abate nuisances before they become very chronic and before they become issues. We've had some properties that are 20-year nuisance issues. And so being able to take a proactive step on properties that might be leading in that direction, and then having a very clear process and expectation outlined from the city for neighbors, for the property owners themselves, and for the city to follow. So I'm happy to answer questions. Mike is here on the legal side as well. He works with nuisances every week. So I'm happy to take questions, specific questions, or I can go into more detail on specific items.
And I would just add to what you said, we've had a lot of problem with blighted properties and derelict houses, I think is another way that is put. And this nuisance bill would also help us have another tool with regard to those kinds of properties. And Mike, I don't know if you want an opportunity to say a few words, or if you're just available for questions, that's fine too. However you'd like to proceed.
Yes, thank you, Madam Chair, councilors. Yeah, just like Jennifer said, the nuisance abatement ordinance we have on the books now is pretty vague. And I think as all the councilors are probably familiar, we have had, or this, like it hasn't been a priority for the city to really enforce the abatement ordinance that much. And there's been some longstanding cases. And these changes, these amendments will really set forth, I think, a much more clear procedure that benefits everybody, the public and the city staff, so that we know what needs to be done. And hopefully this will avoid some of those, longstanding properties. But yeah, I stand for any questions that you may have.
Okay, and Christine, you did this. I don't know if you want to add anything, or you're just, I know you deal with properties. Christine's.
Yeah, sorry, Counselor. You were breaking up on my end, but I was trying to try a different device. I can stand for questions, Counselor Romero.
Okay, I was going to give you the opportunity to talk about the need, but if you're just here in case we have questions, that's great. Bassett Sanchez, I don't know why you pulled this item, so I'll give you the floor, and hopefully our reception will improve.
Wonderful, thank you. Yeah, I'm getting an echo too, so really a lot of echoing. Okay, I will try to speak. Christine, I think you're unmuted on 2 devices. Can you try to mute yourself?
Sure.
And Mike is unmuted as well. It might help a little bit.
That sounds better to me. Does that sound better to everybody else? Okay, wonderful. So I was able to speak with Jennifer a little bit. Sorry, I have a partner right now. I was able to speak with Jennifer a little bit about some of the assignments of who's going to be taking this on. So in the bill, it says that there will be an assignment of a city representative to determine the presence of a nuisance, as well as approve the abatement plan, and then whether or not that abatement plan has been met. So I was hoping, Jennifer, you could just share some of what we discussed with the public and with the rest of the committee.
Sure, Chair, Councilor Casas Sanchez. The reason we left it kind of vague in the bill itself and just left it as kind of the city or a city representative is so that this bill will be a long-term solution and we won't have to amend it if there might be city restructure. Right now it is housed in constituent services, and the agreement is that it will continue to be led by constituent services, but it really is a cross-departmental bill. So I know Mike and Christine meet with PD and with land use every single week, and with our constituent services specialists every single week to discuss these, and that will be carried through and be maintained by constituent services. We discussed having it put into legal to kind of give it a weight to it, but that there become some issues if this does end up going to court. It's difficult to defend if you've been involved too much in that process to begin with. So that's kind of why it's housed in constituent services and will be housed in constituent services.
Thank you. And can you also talk a little bit about some of the technological improvements that we are planning in order to make this less of a manual process and how we can really be doing a better job of tracking?
Sure, Chair, Councilor. Right now, this is kind of a more manual process. It is mostly done in those weekly meetings where these departments that are involved in nuisance properties kind of cross-check their properties with each other. That's going to continue for a little while. But as the city is adopting some more tech solutions, some more data platforms, we are looking to figure out a way to get the 3 data sources that would trigger a nuisance, which would be our constituent calls, our code enforcement violations, and police and fire calls. So our public safety responses into one kind of consolidated notification system. I think there's ways to do this with existing platforms with our Esri system, but we are working to get that data kind of in one place. A lot of it's very protected, it's very sensitive, and so we have to be really careful about who has access to that and make sure it needs to be hidden, and the people that are reviewing this doesn't need to know everything until it really triggers a violation. But we are moving in that direction, trying to streamline this, trying to get kind of an automatic notification system set up.
Thank you very much. And I believe this might be a question for Mr. Prince. So I was talking with Jennifer a little bit today about instances where we have a landlord who owns a property, they have a tenant who might be the ones causing the nuisance. And I think I'm more just thinking through this process, and I'd love to hear a little bit of your perspective. We talked a little bit about making sure that those tenant protections are in place, but also, you know, if there are situations where a landlord is trying to address a nuisance that is potentially being caused by a tenant, I'm assuming that they probably have other legal resources that are at their disposal if this is occurring, and therefore the city is really focusing on the landlord. Can you just talk a little bit more about that? I don't necessarily have a concern with it. It's just kind of fleshing out what this picture might look like for an individual who rents to somebody and they have large parties constantly, and we decide that this is a nuisance. And then they're getting fined, but they also have a lease. How do we address particular situations like that?
Yes, thank you, Councillor Castellanos, Madam Chair. Those are probably in some ways, the most difficult situations when you have a property owner that's not living on the property and renters that are causing the problem. You know, one hopes that the renter or the property owner has a lease with the written lease that they could enforce that hopefully says, you know, if you cause a nuisance or you're breaking the law, I can go to court and evict you or start that process. And that would be actually, you know, because some of the problems sometimes is there are some just landlords out there who don't know who maybe don't have they have bad leases or no leases at all. They have renters. There maybe just they don't understand that they do have resources that they could use to get rid of bad renters that are causing problems. But I think with this nuisance bill, I think it will improve even that type of situation because if we make an abatement plan, we do even try to work with the property owner a little bit, and we can help them to come up with solutions to address the problem, such as, you know, first of all, screen your tenants better, and maybe put things, you know, have a written lease that says you can evict your renter if they cause a nuisance. Maybe there's physical things, build a fence or something, or just be on the property more. Don't just be an absent landlord, or get a property management company to manage the property, or even in I guess a worst case scenario, hire a security guard to be on the property if need be. I mean, and that's what we would put in the abatement plan to try to help the property owner sense. I mean, that's what this is all about, is trying to want to just abate the nuisance, obviously. But those are very difficult situations. There are maybe even more absentee landlords here than elsewhere, I could say, but there probably are quite a few. And the renters, it's hard to get leverage over them. Of course, if there are crimes, you know, it takes a whole team. It takes the neighbors to call in. It takes, and then the police to respond, and the police can tell the renters that they're causing a nuisance. They do have that power, and code enforcement. But yeah, those are difficult situations. So I kind of understand your concern, or how can we better or best address that type of situation. I do think this should be an improvement in that direction.
Thank you very much for that. Yeah, I think what I'm hearing, which I am really liking as I've spoken with Jennifer earlier in the conversation now, is that, and correct me if I'm wrong, this sounds like it's going to be very much an iterative process with the city and our community members of really trying to work with them to look at some plans. We do have some teeth behind it in case there's, you know, an unwillingness to be working with us. But I really do appreciate that the thought was put into how do we work with our members, and also how do we work together as a team at the city. Because there are definitely going to be some, it sounds like there's also going to be some places where there might be a bit of judgment calls. And that's, again, that's kind of that question of thinking about where does the buck stop? Who at the end of the day has that final call? So that's a piece that I know that we're leaving it a little bit open for some changes, but I think it's a good conversation to decide at the end of the day, where does that responsibility fall for deciding, is this a nuisance? Have we worked with them, appropriately to establish that abatement plan? So I think that's still a question that I might want to see a little bit more information of at the end of the day, where does this line get drawn? Although I do appreciate the ability for the flexibility and for the discussion and really working together as a team at the city as well as with our community members. So thank you for that. I don't believe I have any further questions at the moment.
Councillor, I can speak to that a little bit, kind of where the line gets drawn. It is built into the process. So basically, if you go through the abatement, so if you're triggered and you get your 6 calls in 6 months, then we notify you of an investigation, you go through an investigation. And this is internal, this will be done in constituent services. We'll look at the nature of the calls, how frequently the calls were, the severity of the issue. We'll talk to some neighbors if they were the ones who complained. And if it's deemed to be a nuisance, we'll notify you that you need to submit an abatement plan and that you have an official violation. Then we go through this abatement process, which is very iterative. We're working very closely with the property owners to identify the issues and identify workable solutions. And then it really doesn't even, we kind of institute the teeth at this point. So if they've gone through the abatement process or they refuse to submit an abatement plan, or if they submit an abatement plan that's been approved and they don't follow it, then we start fining them. And it's $100 per day for 90 days. And at that, if they are still not paying or if they're still not complying with the nuisance ordinance, then we would basically stop their fines at that point at $9,000 and take them to district court. And this is where kind of the rubber meets the road, and the court will decide really what has to happen with that property. Do we place a lien on it? There's a lot of other things that the court can decide to do. But at this point, we have this whole process and we have documentation of working with the property owner and attempting to really rectify the situation even before we started instituting fines. So it really does give the city a lot more legs to stand on when we do end up at court, which is where I would think the real, if it gets to this point, which we don't anticipate a lot of property owners wanting to go all the way to court, we're hoping and we anticipate that the abatement process will be enough for most of them. But if it ever does get all the way to court, we would have a very strong case at this point. So that's kind of, if the whole process works out in worst case scenario, that's kind of what would end up happening. And Mike can speak a little bit more about the burden of proof that's required there and what those cases look like. But that's kind of the process on the city side.
Mike, did you want to?
Yeah, sure. Yes. Thank you. Thank you, Madam Chair, Councilor Castellanos. I know Jennifer did a pretty good job, great job really of explaining the process there. And I just kind of lost my train of thought, but yeah, but the system, so and Jennifer, I also have to say, Jennifer really did a lot of the work on this amendment so I want to give her that credit. But yeah, so the process that has been or will be in place will just have so much better due process for the property owner that it'll make it so much easier to go into court and say, look, we gave this person the notice, we worked with them, or whatever the case may be, and we followed our procedures, and yet now here we are in court, and it'll just make it a lot easier, I believe, for the judge to say, okay, yeah, then if it comes down to going to court. I think, as Jennifer said, I don't anticipate many actually going that far, but if they do, yeah, we'll be much better situated to, I think a judge would just look at it and say, okay, yeah, I'll declare this a nuisance, and then we'll talk about what remedies can be done to abate the nuisance. Thank you.
Wonderful. Thank you both so much. You're right. I stopped at the abatement process. I forgot to go all the way. So thank you for taking us all the way through the worst case scenario in this process.
Okay, Counselor Casa Sanchez, are you finished? Okay, Counselor Villarreal.
Thank you, Madam Chair. Just wanted to note that this particular update to the nuisance ordinance has been very important to me, especially in District 1. Since I've been on council, we've had two major situations related to properties owners that weren't really stepping up to take care of issues, whether it was related to drug deals and safety issues. And so I am supportive of this, and I think this this will protect or at least help improve the safety and well-being of our residents. There was one thing that I think in the past we were struggling with, and this was what prompted us to look at the nuisance ordinance, is really having a paper trail to back us up on what was happening at a particular property. And there was one in particular that we still are working on that's been over 30 years that has created problems for the neighborhood. And so I think it's good to be able to have some way to track consistently a problematic property. One thing that I would love the Chief Padilla, I think, is on the call with us. I would love for him to explain a little bit more about how these changes will support the police, and specifically about how you all would proactively be able to be trained in understanding this particular adjustment, and so that you all, at least the police force, would know what is considered a repeat nuisance, and also what's the difference between a repeat nuisance and someone just calling for an emergency assistance. So I don't know if the chief can jump on and talk about that, and how the police department will proactively be trained around this particular topic.
All right, I don't know that we forewarned the chief that this is a topic he would be addressing tonight, so I'm a little reluctant to put him on the spot. He's also not unmuting. I don't know, Jennifer, can you weigh in on that if the chief is unavailable?
Yeah, it looks like Christine wants to speak on this.
Okay.
Well, Jen, if you've been in communication with them, you can definitely take the lead. If not, I can touch base on the conversations I've had with the captain and the lieutenants on it, but I'll let Jen go ahead and speak
and this is not to put them on the spot. It's just to show that there is a piece of communication that we have been working with the police department on this, and that this helped their job too. So I think that was kind of the goal of my question.
No, absolutely, Councilwoman Villarreal. I think that's been the key to all of this, is really how we start to communicate and the proactive steps that we've taken. I know the police department just switched their technology to one solution. So we're looking at different triggers within that new technology that will allow us to have better communication, even within the police department. But we're working on a different policy with, and Chief Padilla said he can pop on also, but we're also working closely with PD on a policy for them with the nuisance. But we're really excited for the technology they're putting in, and then the new collaboration that we've had. And we've really been working through the protocol piece of this legislation for several months. Between constituent services, land use, and the police department. And we're really happy with the proactive measures that we've been able to take even within the police department, and flagging properties well before they hit 30 years. That's the goal. And we've even had properties, I think, that probably could have gone on to be nuisance properties, but because of the collaboration and the flags, and then the involvement from the attorney's office, we've been able to notify properties almost immediately that they've had issues, or they've had tenants that have had issues, and the landlords have been able to address that, at a much within days or weeks. So, but I'll let Chief Padilla pop on also. Chief.
Great, Chief Padilla, if you have comments, now would be a great time.
Yes, Madam Chair, committee members, good evening. Always ready for everything and anything, but it's, yes, long overdue that this ordinance finally gets some teeth and we can move forward with it. But Councilor Villarreal, yes, we will definitely update everyone and anyone here within the police department, especially our patrol officers and support operation officers, who respond to these types of offenses and properties for that documentation, and then the completion of that additional report that goes over to City Attorney Michael Prince. But definitely it's the execution of a search warrant at a property, conviction or charges of battery, possession of drug paraphernalia, a disorderly home, the discharge of a firearm on a property. And then obviously it goes into the storage of unoperative motor vehicles on a property. But what we primarily deal with is obviously the executions of a search warrant, whether it's narcotic related or it's related to some type of prostitution home or a homicide property resulting in a bad, lengthy history or crime of the individual there. That's at that point where we're going to do it. I was listening earlier when you guys mentioned and spoke about, hey, someone report of a loud party at the home. At that point, the officer would respond there, deal with the party that's there and tell them to either quiet it down, or it's maybe 50 people at this home that are causing an issue and it's that rental property. Then at that point, it's that fine line. Okay, it's 5 people having a party or it's 50 people having a party. As of now, I don't think just one isolated incident would warrant that we would document it as a nuisance property and route it to Michael Prince and anyone else that would be assisting. We would just say, okay, at this point, you guys need to quiet the party down. If we do have to respond back, well, then we may have to take some type of different action because you're disturbing the upstairs neighbor or the neighbor who lives across the street.
Excellent. That was helpful. Yeah, I just want to make sure that before it was hard to designate nuisances when you all were responding to calls. And I think this allows for another level of scrutiny.
Can I speak a little bit on this too?
Yeah.
Thank you for your question, Counselor and Chair. I think the great thing about this ordinance is that it doesn't take any power away from PD. If there is a very serious nuisance or if there's illegal activity, that can still be pegged as a nuisance and sent to Michael Prince. However, we also now have this, it's kind of an expanded look at nuisances that include constituent complaints and code violations that could very easily be nuisances if they are chronic enough, if they're frequent enough. So even if it's 2 people being loud, but it's night after night after night, the police officers would never constitute that a nuisance because they look at things, you know, at a case by case. They go to the home and they're not necessarily going to flag it as a nuisance, especially if it's not the same officer responding every single time. So that was one reason why the previous ordinance was very difficult to enforce, because it was completely in the hands of police to make that call, and they don't necessarily have the resources to be scanning all of their calls all the time, scanning for these kind of minor issues that can become major issues over time, or major issues if they're frequent enough. And so while PD still does have that power to flag a nuisance at any time, we are now looking again more proactively across departments at different kinds of violations, and hopefully pegging properties as nuisances before they become really serious. So thank you, Chief, for your comments. It's really great. So I think that's one of the big benefits of this.
Great, thank you, Jennifer. Councilor Villarreal, do you have other questions? All right, if there are not, oh, I'm sorry, Councilor Garcia.
No questions, Madam Chair. Just want to thank the sponsors for bringing this forward, and if I could be added as a co-sponsor. So if I need to, I can reach out to Jesse to do so.
Great, we can make that happen. All right, if there aren't other comments, questions on this, would love to entertain a motion. Okay, we have a motion by Councilor Villarreal.
Second.
Second by Councilor Garcia. If there's no other discussion, we could have a roll call. That'd be great.
Councilor Villarreal,
Yes.
Councilor Garcia,
Yes.
Councilor Casas Sanchez,
Yes.
Councilor Rivera,
Yes.
and Councilor Romero Worth.
Yes.
Motion's approved.
Thank you. Thank you. All right. Thank you, everybody. That was good discussion. Going back to my agenda, we are done with our consent agenda. We do have a presentation tonight regarding the Santa Fe Police Department's existing policies on use of chokeholds, the duty to intervene, and duty to administer first aid. And Chief Padilla is here with us tonight. I thought it would be a good idea to just get some information out there about the fact that we have these policies, and hear from the chief a little bit about how they work for law enforcement as they address the situations that happen in the city. So Chief, I turn it over to you to kind of give us you have a wide-ranging opportunity here to talk to us about these 3 policies. Thank you for being here.
Yes, Madam Chair, committee members, good evening. Thank you for having me tonight. This is in line, like I said, with our use of force policy. We last updated it back in 2016. It's been in place right now for 4 years, and all the things that you just mentioned are covered in our policy. And I'll start off with the introduction of the policy. It's the policy of the Santa Fe Police Department that employees shall use that force which is reasonably necessary and constitutionally permissible to protect the sanctity of human life, preserve and protect individual liberties, and to effect lawful objectives. And then it continues on, and I don't want to be too long-winded, but just please bear with me. But the use of force by members of law enforcement is a matter of critical concern both to the public and the law enforcement community. It is recognized that some individuals will not comply with the law or submit to control unless compelled to do so by the use of force. Therefore, law enforcement officers are sometimes called upon to use force in the performance of their duties. It is also recognized that members of law enforcement derive their authority from the public and therefore must be ever mindful that they are not only the guardians, but also the servants of the public. The department's guiding value when using force shall be reverence for human life. When warranted, department personnel may objectively use reasonable force to carry out their duties. Officers who use unreasonable force degrade the confidence of the community we serve, expose the department and fellow officers to legal and physical hazards, and violate the rights of individuals upon whom unreasonable force is used. Conversely, officers who fail to use force when warranted may endanger themselves, the community, and fellow officers. That is how this use of force policy starts off. That's the introductory page that all of our officers are trained upon. So I wanted to start off there and then go into the concerns and the topics here, which is the ban on chokeholds and strangleholds. Chokeholds or any kind of throat or neck restraints are not permitted for custody and control while an officer is making an arrest. Duty to intervene. Officers have an affirmative duty to intervene where they witness another officer using excessive or unreasonable force in any situation. And then at any point an officer were to use or deploy some type of force, ranging from an empty hand strike, a tackle, a takedown, deployment of a taser, deployment of pepper spray, a baton, all the way up to deadly force with the deployment of a shotgun, a pistol, a rifle, then at that point, that officer has to render aid. They have to seek medical treatment for that person that they use the force on. They have to photograph the scene, photograph the individual, render or call for an ambulance to come check out that person. And then eventually they still have to take that individual to the hospital so they get a full medical clearance, which is in end what we're going to use to document the incident even further. And that medical clearance is going to be needed when the officer or officers take that individual over to the jail. The jail is going to need that paperwork to say, hey, did you medically clear this person? You can obviously see that their eyes are irritated when you pepper sprayed them, or you in your report or booking information, it says that you had to tackle them and they have an obvious abrasion or scrape to their face or forehead. The hospital is going to have to give that clearance before the jail would accept them 100%. But I'll stand for any questions.
Chief, are you at liberty to talk about the incident at the, what is it, ranch, the store, the ranch store, Big R? I think I'm.
Yes, Madam Chair. Yeah, you got it. Big R there at the end.
Big R, I'm sorry, it was not coming.
Yeah.
And I believe that the duty to administer first aid came into play. I don't know if I've heard rumor. Just curious if you're able to talk about that as a kind of a real life example of one of these policies.
Yeah, Madam Chair, committee members, I won't talk about the specifics that led up to the incident itself, because obviously that's still under investigation by our department. And then the officer involved shooting which involved the 2 officers there that deployed their service pistols, that's under investigation by New Mexico State Police. But that third arriving officer was able to arrive there and assess the scene. She ran up to Mr. Galasini, and then at that point, she applied a tourniquet and she stopped the bleeding, not only on his arm, but on his chest until the paramedics arrived. Doesn't matter that he was just once trying to attack an officer or officers. We have to render aid, whatever force that we used on that individual or individuals. We at that point, hey, it's to stop their actions, render the scene safe. And then at that point, we need to render aid, call for the paramedics, and then eventually take him over to the hospital like they did. So they did provide some life-saving efforts that day.
Okay, thank you. I just wanted to give you an opportunity to talk about how these policies, get used in your day-to-day interactions. And I don't know if there are other situations or stories you want to tell. Just want to give you that opportunity at this point.
Yes, Madam Chair, committee members, after each deployment of any type of force, as I mentioned a bit ago, the supervisor is required to document the whole incident, put this package together, and then at that point, it's routed over to our professional standards division. And then on a quarterly basis, they review every use of force or show of force. And at that point, they determine, was it excessive force? Was it within policy? Is remedial training needed? Has a recent trend changed nationally or locally that we've received direction on? And we just got to make sure that we're up to date with the latest and greatest information that's out there. And then once that committee is done reviewing those incidents, I review each individual incident to see, do I concur with that committee's recommendation? Was it in policy? Was it out of policy? Are there any concerns? Do we need to have an updated roll call training? Do we need to have a 40-hour block of instruction because handcuffing techniques changed, or we're seeing concerns that officers are thinking that they can deploy a taser in this type of situation, but in all reality, they can't do or deploy that taser in that manner or fashion.
Okay, thank you. And you mentioned that these policies that you were just describing went into effect in 2016. Is there a periodic review? Is it something that you do every 5 years, every 2 years? How do your policies get reviewed? And where are we in that cycle in terms of making sure that we're right up to date with whatever the new situations are that are rising, and new thinking and new techniques perhaps in law enforcement?
Yes, Madam Chair, committee members, definitely they're reviewed almost on a daily, weekly basis. Although the policy was last updated or put into place in 2016, if something major were to change through the Law Enforcement Academy's curriculum, or we were to change and get rid of the use of batons or tasers, then at that point we would definitely update it. For the last 6 months, we've had a dedicated lieutenant or an administrator reviewing all of our policies, all 100+ policies. So at this point, we are going through a policy by policy review and update, so we can update them and put them into an easier format for everyone to read and then be searchable as well.
Okay, thank you, Chief. I do have some questions from the committee. If there's anything else you'd like to add, we will go to questions from the committee.
Madam Chair, I have nothing else to add, and we'll sit here for the questions.
Okay, great. Councilor Garcia, your hand is up.
Sorry about that. Thank you, Madam Chair. Thank you, Chief Padilla, for being with us. What actions are taken against an officer should they use a prohibited hold like a chokehold, or did not intervene, or in the instance of you gave the example at Big R where the third officer showed up and administered first aid. If she showed up and said, nope, I'm not going to do that, what are the next steps?
Madam Chair, Councilor Garcia, so if there's any violation of this policy itself, just like there is with any other policy, at that time, that supervisor would document the incident and notify their chain of command, which is that next level of supervision going on up. And then at that point, we would conduct an investigation. We have two types of investigations, which is an operational complaint, a lower level type of investigation, where maybe an officer might have skipped a step, like, hey, they arrested someone, they deployed the taser and they called the ambulance. And then at that point, they photographed the scene. And then at that point, the ambulance personnel said, hey, the gentleman does not have to go off to the hospital. They just go off the word of the paramedics, and the officer takes that person to the jail. But hey, per our policy, even though the paramedics say, hey, he just had these two marks on his body from the probes from the taser, it's still our policy that the officer has to take this person over to the hospital and get that full medical clearance. The higher level investigation is an administrative investigation or internal affairs investigation, where at that point we feel that the deployment of the taser or any other type of force was definitely not within policy, or there was an allegation of excessive force. Then at that point, we would do the full larger investigation, which is that internal affairs investigation, which is at that higher level.
Okay, thank you, Chief. And kind of gets me into my next question, which is, I guess, a two-part. How many times are these incidences reported? Where an officer deems maybe another officer used excessive force or didn't render aid. And then, the second part of that is, how many instances were deemed to be in violation within the past 6 months, year? I don't know if you have those stats available, but I definitely think that would be great to have in regards to how many of those instances were deemed to be in violation, so to speak.
Madam Chair, Councilor Garcia, so within the last year, there's one case that comes to mind where it was an allegation of excessive force. So we did do a full internal affairs investigation on that case and situation. And it was a sustained policy violation of that incident and policy. So there was corrective action taken with the employee. But all the other incidents that were used in applications of force were within policy.
Okay. Thank you, Chief. I appreciate that. As we move forward, because I know that this has become a very sensitive subject for the community, what means are there to communicate to the broader public in regards to reports of excessive force, and then the final outcomes, the determinations of that? Could a public member request that information? Is it something you publish? What's the process of that?
Madam Chair, Councilor Garcia, all of our incidents or applications of force are documented in our annual report. That's in its final stages of getting finalized at this time, where it talks about how many taser deployments there were, how many deployments of a baton use or empty hand or open hand strikes were used and deployed, all the way up to lethal force with the deployment of pistols, weapons, shotguns, or those rifles. All that's covered in there as well. And that's something that's been covered in a annual report, but we know now this is something that we should be reporting on, just to be open and show that we're transparent with the community, to let them know that we're not trying to hide anything and this is what we are doing. So this is something that we can currently cover in our monthly public safety meetings. Obviously, with COVID crisis in place, that those committees might not be open and available and resume till September at the earliest. But I think this is something that we can compile and release and say, hey, look, in 2017, these were the results per our annual report. In 2018, we do them on a calendar basis. And then in 2019, here were the results. And then I think for this last handful of months to current present date, for the last 6 months, we can hopefully compile some type of data, chart, and graph and say, okay, and just an example, out of the 20 deployments or shows of force, these are how many were in compliance of the policy or directive. And here are the ones that we deemed that were out. And did we receive any citizen complaints or complaints from the arrestee that there was an allegation of excessive force? But yes, we are ready to prepare and keep the public and the community members informed.
Great. Thank you, Chief. And last, I just want to thank you and all your fellow officers in the department for keeping Santa Fe safe. I think, as I mentioned earlier, this is definitely a trying time for not only Santa Fe, but across the country. And I want to thank you for your service and all of the other officers within the department. I know that it's a stressful time, but I do want to thank you for your service to our community. That's all I have, Madam Chair.
Thank you. Councilor Rivera, you are next on my list.
Thank you, Madam Chair, and thank you, Chief, for being here. So the first question I had was on the use of cameras. Are they always in play? And if not, when are they utilized?
And Madam Chair, Councilor Rivera, so we do have an in-car camera policy, and it dictates and says when an officer is going to activate and use their in-car camera system. We've had that policy in place for the last 20 years, and it's been updated as we've upgraded to different camera systems. So like a traffic stop, when an officer responds to a domestic violence situation, they respond to a crash. Those are the instances when that in-car camera system is going to be an operation. For the body-worn camera policy, we've had that policy in place for the last 4 years as well. It went into in place in August of 2016, and we have been using those body-worn cameras for 4 years now. So same thing, if an officer is going to have that contact with an individual where it's going to result in some type of questioning for some violation of a city ordinance or state law, then at that point, that officer is going to activate the camera, which kind of goes in line with the in-car camera policy. If the officer is conducting a traffic stop, responding to a domestic violence situation, they're responding to the local store establishment for a shoplifting case, then at that point, that officer is going to activate that body-worn camera policy.
All right, and then you talked about medical assistance to, in this case, we provided the one at Big R. Do all the officers carry tourniquets, and have they all been trained on really stopping bleeding by other means besides tourniquets?
Yes, Madam Chair, Councilor Rivera, yes, every officer, to include myself, goes through that training of Stop the Bleed, which is application of tourniquets. Every officer carries those tourniquets either on their person or in their police vehicle, and then they know how to stop the bleed if you can't apply a tourniquet where you have to apply pressure or gauze or any other type of material to stop that bleed.
All right, so they do carry some minimal supplies, I guess, to do that?
Madam Chair, Councilor Rivera, yes, they do.
Okay, good. You talked about state police investigating that incident at Big R. What gets investigated by an outside entity versus what stays with internal affairs when it comes to the use of force, any kind of force?
So Madam Chair, Councilor Rivera, that's a great question. So the only time we have an outside agency investigate that application of force is when it results in great bodily injury, like what happened at Big R, or if we do apply that force and it does result in that unfortunate death of that individual. Then at that point, that outside agency is going to come in and review that application of that great bodily injury, or in the end result that someone does pass away. That's when they're going to investigate it. They're going to document the incident, review everything and anything, all the data that's there on scene, from in-car camera systems, body-worn camera systems, witness statements, surveillance videos. That's what they're going to investigate. And then at that point, they're going to render and finalize their report. They refer it over to the district attorney's office. And then it's up to each district attorney. Do they do their own independent review, or do they follow that practice where they convene a panel, and then at that point they review the incident itself, and then at that point they decide, was that application of that force, was it justified? If it's not justified, then at that point that's when criminal charges could be filed against that individual officer or officers.
So the use of a taser or the use of like a beanbag shotgun, those would be handled internally?
Madam Chair, Councilor Rivera, that is correct.
Okay, do those get looked at internally?
Madam Chair, Councilor Rivera, yes, every application of any type of force, from the beanbag shotgun to pepper spray to a hands-on technique, those are documented by that first line supervisor, and then all of those incidents are reviewed on a quarterly basis. And then that review committee provides an individual report, cover sheet, synopsis for me to review to see if I agree or disagree with their recommendations or findings, to see if that application of force was within policy or out of policy.
And do you have a policy on how you position an individual once handcuffs are placed on them?
Madam Chair, Councilor Rivera, yes. If that individual is laying down through training, it's called the rescue position. We don't authorize hog tying or allow that individual be left or be allowed to be face down. That's where that positional asphyxia comes into place, where that person cannot breathe. So yes, every officer is in line with almost first aid CPR training. If anyone's ever gone through it, it's called that rescue position, where you almost lay that individual on their side. You pull that top leg or knee upwards. It's almost used like a tripod or a kickstand. And then that, obviously that individual's arms can't be lifted up, but it alleviates and raises that person's chest off of the ground or the floor. And that's what allows him to breathe. If that individual officer has to keep that person down in that rescue position because they're waiting for backup because the person was violent or trying to run or flee from that officer, once the situation is calm, then at that point, that person should immediately be sat up and brought up to their feet, and either individually by that officer themselves, or if another responding officer to get there, then at that point, it's their responsibility to get that person up and, like I said, render aid, get them off to the hospital, have a paramedic check them out, or place them in the back of a patrol vehicle.
And do you think we're pretty progressive in our use of force policies as compared to other places in the nation?
Madam Chair, Councilor Rivera, yes. I said we knock on wood and we don't say that we want to go out there and apply force on individuals. Each individual situation is quickly and rapidly evolving. And at that point, yes, we follow the latest and greatest protocols, training procedures that are out there. Yes, there's always room for improvement as technology improves and changes, and document and procedures change. Maybe one supervisor does it this way. Another one likes to take more pictures and throw a ruler down and measure everything. But we have the basic guidelines that are out there. But anytime some new product comes out or there's a change in protocol, we're always willing to open and evaluate all those practices and procedures. But yes, I do feel that we're in line with the latest protocols and procedures that are out there nationally.
And how often do you train on these procedures? And I assume there's documentation that goes along with each officer's level of training or amount of training?
Yes, Madam Chair, Councilor Rivera, yes, it's up to each individual officer. Not each officer has a beanbag shotgun. A police detective might not have a taser themselves. It's the patrol officers are the ones that have access to that full array of those intermediate weapons. Then at that point, just depending on each level, that beanbag shotgun is trained on annually, where they have to go through that recertification. The taser, same thing, they have to go through that recertification with that taser. Same thing with annual qualifications and quarterly qualifications with the pistols themselves, the shotguns. There is that hands-on training where that proficiency has to be maintained and shown.
Thank you, Chief. Thank you, Madam Chair.
Thank you, Councilor. Councilor Villarreal, you're next.
Thank you, Madam Chair. And thank you, Chief, for joining us tonight. Just follow up on the entity you said has to assess the situation. You said the Professional Standards Division. Is that the state police?
Madam Chair, Councilor Villarreal, no, that's the two lieutenants who work for the Santa Fe Police Department. So it's a unit of the police department that reviews those situations.
As it relates to use of force?
That is correct.
So it first goes through an internal, like to the lieutenants before it goes to the state police for a further investigation?
Madam Chair, Councilor Villarreal, the only time state police would get involved if it's an incident, primarily deployment of a pistol, a shotgun, or a rifle. It's deadly force. But the application of a taser, shotgun, pepper spray, a hands-on technique, that's going to be reviewed here internally as other agencies do within the state of New Mexico and nationally.
So have you seen other options now that this is coming into play and more visible about use of force in our country? Have you seen other models you think could work better instead of having individuals within a department have to assess a situation? Have you looked at other models that might work?
Madam Chair, Councilor Villarreal, one thing that even Albuquerque Police Department is using is that citizen oversight review committee or board, whatever the official title is. I know at this point, locally, that is something that's on the table and we're open to it. Those established protocols and procedures would have to be set within this committee to figure out, okay, at this point, what would be reviewed? Is it every single application of use of force? Or would this committee only review something if there's an allegation by a citizen that was recently arrested that they're claiming that the officer used excessive force? Then at that point, would it just be that insulated or isolated incident? Or would they have the purview to review everything and anything? And those parameters would have to be set and say, okay, do they review everything? And then at that point, review and recommend that it's within policy, out of policy. You know, some people's concerns or thoughts, well, do they have the authority to recommend corrective action or discipline on that individual officer? But yes, Councilor Villarreal, that is something that we have been keeping our finger on the pulse, and that is something nationally that's happening at this point. And if that's something that we want to go with as a community, I fully support it. Like I said, it's all about transparency and letting everyone know that we're on board with them and we're here to help everyone out.
So that's helpful. I guess I'm always of the mindset that internally, always being proactive about how we can do things better shouldn't always necessarily come from just the public or policymakers, that it actually comes from you all, because you also have a role to be accountable for the things that you have to do. And that's why I'm just putting it out there for the possibility of, you know, you coming up with, as a department, thinking about the things that you could proactively do to show that you're being accountable and transparent about ways that you're following up with certain instant or situations. So I'm just putting that out there. The other piece was, my colleague had asked about trainings, that if you do updates to different trainings, but how often are you all looking at ways to look at alternative methods of handling situations like de-escalation situations, and how often do you train for that?
So Madam Chair, Councilor Villarreal, we recently put every officer from a brand new police cadet all the way to myself, about a year and a half ago, something that we had put into our budget and we finalized everything last year, is every officer had to go through a 40-hour de-escalation training. And that's something that we partnered with Dr. Troy Rogers of the Public Safety Psychology Group out of Albuquerque, who was able to come to our location, put every officer through that scenario-based training. So it wasn't just a classroom presentation. Yes, there was some classroom presentation, but it was actually going hands-on, and it was ranging from dealing with someone going through substance use withdrawals on the side of the road, to someone going through a domestic violence situation, to a barricaded subject in a room or a roadway, dealing all the way to someone that's having a mental health crisis at that point. To say, okay, at this point, it's all about talking to someone, reasoning with them, and understanding, hey, this person is not in the right mind, and we have to speak to this person and realize that, hey, look, at this point, we need to talk to them as people and persons and try to get them into the proper counseling or get them off to a local, local hospital at that point, and get them the help that they truly need. And we all went through that training, but that's something that as we move forward at that point, we'll have to see, okay, probably through the next, not this current fiscal budget request, but through the following one. At that point, we'll have to go and put everyone through a refresher training. It might need not be the full 40-hour class. It might just be a 10, 20-hour refresher class. We do have our upcoming annual qualifications or spring qualifications that we have to do for the Law Enforcement Academy Board. We'll have that training start in about a couple weeks. where it's going to result in a refresher training of our use of force policy, reporting, and answer any questions. So that'll be conducted with our officers. That's a 10-hour training day, and that'll be covered of the spring qualifications out at our firearm range. And it's also the use of our firearms training simulator, where the officers go through individualized situations. So if you can picture a large screen at least 15 by 15 feet in front of the officer, it's that simulator where the officer responds and speaks to someone, and the officer and the controller of that scenario or situation has the capability to control that role player, which is a computer based, and it's actually like if you're watching a movie. If that officer is controlling the situation, de-escalating and doing everything properly, then at that point, that administrator can control the role player and show that the person is complying, and we can render the scene safe and get that person into it. And then also there's other situation scenarios where that individual may just deploy some type of pistol or rifle, and that officer has to use and deploy and give those verbal commands and deploy their pistol or rifle and say, hey, look, I'm Officer Padilla, and I'm here to help you. And at that point, if that person has a pistol or a shotgun and they're displaying it, and they might just be holding it by their side, at that point, any law enforcement officer, to include our agency, has that ability to deploy and show their lethal force and deploy their pistol and draw it out of their holster and maybe have it down at the low ready, or actually be pointing at this individual and let them know, hey, I'm Officer Padilla. You need to follow my commands. We're here to help you. Let's talk through this. You need to put your weapon down or throw it onto the ground. And then at that point, if that person were to raise that pistol or shotgun or rifle and try to fire it at the officer, it'll also test that officer's reaction skills and accuracy skills to see were they able to use and respond to that critical situation. But we'll be doing that now within the next couple of weeks. That was already pre-planned and scheduled.
Okay, thank you. And Troy Rogers, what's his background?
He's a local psychologist out of Albuquerque, works hand in hand with all the agencies down in Albuquerque or Bernalillo County. This is something that he does, and he puts it on even just for local stores and agencies and even for dispatchers, but it's de-escalation training. He has all the specialists that work with him. This is a professional. And like I said, we have been using him for about 3-4 years now and expanding. Like I said, he trains all of our crisis negotiation team members. And this is something that he expanded on. And it just took a little bit of a process that we were able to send a few people to this advanced training. They came back and fed it back to us and said, hey, it's a great program. So we put it into one of our fiscal year budget requests a couple of years ago. And then when we had access to it, and I think 17, 18, we tapped into that funding, and then we wrapped up all of that training last year, and took about a year to go through the entire department.
Thank you. Well, we do have a lot of new people, so we'd have to make sure that they get trained in that same sector or that same specific area. I guess I'm just curious, like, given the case that happened in Las Cruces with Antonio Valenzuela, who was killed by an officer, and it was basically the officer was using a prohibited apprehension tactic. And I'm just curious, like, even though places like ours and Las Cruces and other places have ensured that we have policies and procedures, how do we ensure that people actually follow them in situations, and making sure that officers are held accountable? And you talked about the process, but I'm just wondering, like, how can we even prevent getting to that point where we have to think about use of force, but actually making sure that we have the right people and the right jobs so that they know that we take this seriously? So do you have an opinion about why that played out in Las Cruces?
Madam Chair, Councilor Villarreal, I mean, like, each agency is different. Sometimes people let the best of themselves get themselves. That's the way I'm easily able to put it. And as our policy covers it there, yes, the ban or the application of a chokehold during the apprehension of someone, we ban it 100%, and many agencies follow that same protocol. And that's what those officers were doing. And I know that's under review, and those officers or officer may be facing those criminal charges, and we'll see how that pans out. But that was the application, and that's when they were trying to apprehend or arrest someone, and that's when he applied that chokehold. And like I said, then they didn't follow through with that rendering of aid, and they left him in that face down position where that positional asphyxia comes into play. But through the application of our forces, it's up to that first line supervisor and that officer to document and be open and honest and say, hey, this is what led up to the application of force, and this is what was set and what happened. And then that first line supervisor, it's their responsibility to document everything and follow our established protocol and procedures and guidelines and route it up through their supervisors. And then at that point, it's reviewed on that quarterly basis by our internal affairs or professional standards unit. And then at that point, report it over to me to see if there's any discrepancies or we've seen a downward trend or some people or this one individual or isolated officer or group of officers not following the established guidelines. That at that point, we need to call a timeout and call an immediate refresher training on everything, on anything. But nothing comes to my mind in the recent couple years that, hey, we've had to call a timeout because someone was skipping a step from the first line supervisor not documenting something properly, and they're just kind of blowing things off altogether.
Yeah, it's a hard place to understand completely, just because in some regard, there's some subjectivity that occurs, and even in the language that you read about policies and procedures, there's still kind of this like, we ban this use. However, there's this like little caveat, and that's what's hard to understand. Like, at what point does that line get crossed? And so I think it would help to have some other kind of oversight process. And I don't know what that looks like at this point, but I'm open to looking at that and seeing if you all have other suggestions other than what you suggested about the Citizen Oversight Board, but just, we need to keep that communication open on that topic. Thank you, Chief.
You're welcome.
Thank you, Counselor. Counselor Cassett Sanchez, you have the microphone.
Thank you, Madam Chair, and thank you, Chief, for being here. I wanted to follow up a little bit on trainings and how we choose our trainings. And I know that often, at least in kind of the psychology and the public health world, we talk about how trainings change knowledge, beliefs, and behavior. And really what we are looking at is how do we change behavior? I'm curious how you guys evaluate the effectiveness of your training. And I know it's probably a very challenging, it's a very challenging situation because of the types of situations that our police officers are often thrown into. And so it's a very different world when you're in a training situation versus the real world. But I am curious to hear how you guys evaluate whether the trainings that you are doing are working, whether there's been enough, and if it actually is getting to that behavior change place that we would like to see with some of these situations, that we want to make sure our police officers are acting in a certain way when they are under this immense pressure and sometimes in these life-threatening situations.
Yes, Madam Chair, Councilor Cassett Sanchez. That's something that's just evaluated on that case-by-case basis. I mean, each individual incident is different. Not each one is the same. We try to stay up to date with the direction and guidance that we receive from the New Mexico Law Enforcement Academy. We have to follow, at the bare minimum, their recommendations for the biennium firearms qualifications and their annual qualifications forms and qualifications. We follow those, and we have been following them. It's all about documentation. A lot of it as well is covered in biennium training, so we have to do that. And they give us about 2 years to follow up with all the updated trainings, which range from report writing to how we would respond to a child abuse case and documentation of that case. But internally here, if something if someone had an idea, said, hey, look, I'm a supervisor and I'm seeing this trend or this policy is in place and it's unrealistic, or it's an application of force and something changed with one company to another company, how you deploy or use a baton. At that point, we would have to call everyone in, and those instructors would have to meet and say, hey, look, there was a recent change and you can no longer do this with that type of intermediate weapon. So at that point, we need to update our training. But as of now, everything is evaluated, and it's up to our training division to stay on top of the current trends locally, nationally. And at that point, if we transition from, I'll use the taser as an example, just with any other type of technology, you buy something this year, the following year, there's a newer, greater model out there. There's a newer model of taser that's out there, and we'll have a fiscal request in our next budget here in the next couple of weeks or month or so to upgrade to this latest technology. Just like with anything else, it gets upgraded, and with that new technology, there might be some updated training as that curriculum and training program will come with that updated intermediate weapon to say, hey, at this point, with the old taser, this is how you did it, but with this new taser, this is how you need to do it. So anytime we upgrade to that type of technology, prior to us just opening the box and giving it to an individual officer or detective, that officer would have to train and go through the latest training program or curriculum with that individual intermediate weapon.
Yeah, thank you for that. I think my question was actually more trying to get towards not so much as being able to accurately use technology, which is good. I'm very glad that we're updated on that. That's important. But really looking at that decision process, you know, and are we seeing situations where we feel that the decision process is not what we would like it to be? How are you analyzing that, and whether or not there is additional need for trainings, or perhaps the trainings that are being deployed are not as effective as we would like them to be within that decision process? Does that make sense?
Madam Chair, Councilor, are you talking about like applications of force or like a reality-based training where Officer Padilla would respond and there's an individual sitting on a park bench, and then all of a sudden that individual stands up and runs from myself, and then maybe that individual stops and then deploys or shows a firearm and tries to shoot me? Is that what you're trying to go for?
Yes, I believe that is. Thank you for putting an actual training on there. So I have that example. So exactly that. So how do we know? And then when we're looking at situations in the real world, you know, seeing that we're feeling that training is there, that our officers are really following that continuum of force, and that that those correct decisions are being made. And if we feel that behavior change that we're wanting is occurring.
Yeah, Madam Chair, Councilor, that's what's evaluated by our training unit, which is a group of officers and a supervisor that come up with this annual training, which we're about to kick off in a couple of weeks. It's up to them to say, okay, this is what they're seeing in communications with our professional standards unit and division, to say at this point, are there discrepancies with maybe documenting the incidents themselves or the actual application of the force? Are we seeing something that's wrong, or are we following those policies? Then at that point, it would be up to that unit to say, this is the trend that we're seeing. And obviously I would know of those discrepancies or concerns. And yes, I would approve of that training or updated curriculum to go into effect. But that's through that Farms Training Simulator. So at any point, if any of you all would ever like to try to come in and run through those training simulators and situations, and we would give you a quick rundown and show you, here are those split-second decisions that these officers and detectives are having to make out and about on a daily basis, from using their verbal skills and that verbal de-escalation, where we obviously want every situation to go, but there's certain individuals or situations where speaking to someone is not going to work, and that person is going to try to harm either that officer or a family member or some other random person. And that's where that officer has to move in and intervene to save someone's life and stop that person's action. But anytime any of you all would like to partake in our Farms Training Simulator program, it's nothing that's too wild or crazy where we're going to have you running, jumping, or climbing over walls. It's just, like I said, you would be given that scenario and training, and you would have to go and see what you guys would be able to do to de-escalate that situation or possibly apply some type of force.
And thank you for that. I'm really happy to hear that the real life situations are really informing those trainings. I think that is important. So I'm very glad to hear that is part of that process. You know, to kind of piggybacking off of some of what Councilor Villarreal was talking about is some of these different models that are coming out about public safety as a whole, and where we might be where we are thinking that police officers, where we really need our police officers, where we should be focusing them to make sure that we are keeping the public safe, and where potentially there are opportunities to use different professionals that, you know, I think we've had so many conversations about how our police force is stretched, and that there are potentially situations where we could be using mental health professionals, other individuals that could come forward and assist with some of these situations, potentially with the homeless population, or somebody that, you know, we do see a mental health situation and we don't think that there is a danger. I'd be curious to hear your thoughts on those models that have been being discussed.
Yes, Madam Chair, Councilor, the Fire Department, Chief Paul Babcock, through this next fiscal budget, like I said, you guys will all be hearing his pilot project, hopefully within the next 2-3 weeks. We want to partner with him and then also with the Community Services Department and have this mobile unit. This is something we've been talking about for about a year now. And at this point, he was able to put it forth in one of his proposals, an expansion proposal. And at that point, what we'd like to do is have that mental health professional or that case manager and a police officer and a firefighter from the MIHO program all ride together, work out of one office. And if they know that over near Pete's Place, there's individuals that are in need of help, they would go and speak to those people. If they know that there's a call for service at the local Walgreens right down the road and there's an individual there causing a scene, maybe they're aggressively panhandling, which is against one of our city ordinances, and they would respond to that. And at that point, they would say, hey, Andrew Padilla, what's going on today? And they would hopefully build that rapport with that individual and try to get them connected with services to help them get back on their feet and be a productive member of this community. That's the entire goal. That's a pilot project, but yes, we're always open and we would love to see that the city would step up and have this individual unit either reporting here with the police department, working with the fire department, working with the community services department, where an officer wouldn't have to respond to every welfare check that maybe it's someone that called the crisis hotline and was feeling suicidal, or a family member has a concern about their loved one. Or it's that individual officer, individual calling the police and saying, hey, look, this is what's happening. So it's not always that police officer responding right away from the get-go. We could have these other mental health professionals in place to also respond in line with us hand in hand. Or, you know what, just individual calling saying that they're having a bad day or they're feeling down. At that point, we would hope that obviously law enforcement would have to respond at all. And these mental health professionals or counselors would respond and they would be able to help connect with this person, get them the help that they need.
Yeah, wonderful. I had heard some musings about that proposal, so I am really excited to hear about it. I think that could be really beneficial to our community. Do you think that this would also be beneficial, and how so, to our police department?
Yeah, Madam Chair, Councilor, like I said, it's a great pilot project, and I think we can hopefully expand it. I think if it kicks off, and with the budget and COVID crisis that we're in now, by the time the whole thing's established and set up, it'll probably be October, November, December, and by then months have gone by and we're going to be mid-year. I mean, if it does have that success, and we'd have to figure out when are those calls for service truly happening that are affecting police department response and fire department response. Just an example, if they were all working, I don't think it's just gonna be a Monday through Friday 8 to 5 job. I think this is where maybe that their hours might be from 10 a.m. to 8 p.m. at night, and they're gonna try to at least have at least 4 or 5 days of coverage. And I think we can all agree that this is the help and this is the direction we all want to go forth with this community and this national trend and having these specialists respond to these types of situations, so firefighters and police officers don't automatically have to respond there and possibly escalate these situations. So it'd be great by mid-year to say, hey, look, here are the number of calls for service that this response team has responded to. It was a pilot project and we are seeing success, and here are the 10 success stories out of it. Now they're all productive members of the community, and maybe they've responded and built rapport with 30 individuals, and 10 of them are responding to the programs, and with the other 20 individuals, we're still trying. I think hopefully by mid-year, we can show some type of stats and data and use that and say, okay, this program is working and we do have the staff and resources to expand it by another 3, 4, or 5 individuals and dedicate more officers and firefighters and go that route. Or by mid-year, we realize that, hey, look, although they're doing their best, we still need to give it another 6 months and see how we're looking and review for the next fiscal year to see, okay, at that point, do we just stick with it as it is? Or does, through the community services department, do we need those counselors and mental health professionals? And they are the ones responding to this. But yes, officers have to respond to a variety of things on a day-to-day basis, from neighbor disputes to someone sleeping underneath a park bench to someone sleeping on the side of the road or in the neighborhood near Pete's Place, or Midtown or St. Elizabeth Shelter or the downtown area, you name it, an officer is responding to it. But I think we can all agree that an officer doesn't have to respond to these types of situations all the time. And long as that person is being respectful and they're not trying to physically fist fight that counselor, I don't think any of us would agree that if we did go this route and we had this counselor or this mental health professional, that they would just be driving around by themselves, riding around with just a cell phone and a clipboard and some pamphlets trying to connect and get these people with the resources. I think at the bare minimum would have to be a 2-person response. And if Andrew is that counselor engaging with this person going through that crisis of the day or situation of the day, that other person still has to be that safety officer to say, okay, so in case something does go bad, that they would be able to call 911 and call in those officers, because now they're physically fighting, or that individual that was going through some type of crisis now is threatening suicide, or they're physically fighting that first counselor, or they've drawn some type of weapon and they're trying to harm them.
Yeah, thank you for that. I'm glad to hear that, we're really thinking through this process and kind of all the different scenarios. I'm really looking forward to hearing how this goes. And I really, I hope that we can continue to get updates about this, either here or through, public safety or through council. And I just want to thank you for really starting to look at some of these innovative programs, some of these new directions. I really, appreciate that look towards how we continue to improve. I think that's really important. And I know right now there's really a national movement happening. And I hope that we continue this momentum, even if there is no longer a national momentum or movement happening, and or it's taking a dip. So I want to make sure it's something that we are really continuing to look at, and continuing to see how we can improve and how we can be a leader in this area, because I really think that we have that opportunity. So thank you so much again for being here. Thank you to your work and to your staff. I really appreciate it. That's all.
Madam Chair,
Yes.
before we leave that point, can Chief Padilla, the pilot project you're talking about, how does that get funded?
Madam Chair, Councilor Villarreal. So at that point, the police department would provide a police vehicle. It wouldn't be fully marked. It would be an unmarked vehicle. It'd be through existing. Obviously, we would probably pay for the fuel for that vehicle and maintenance. We would use a current officer or detective that would want to do this type of project. We'd go through a selection process and say, okay, who wants to do this type of project? They would apply for the project. And then at that point, they would be a member of that team. Same thing with the fire department. They're not going to hire any new staff. They're going to use the same existing staff, either a member from the MIHO program or one of their other paramedics or EMTs to participate in this project. That caseworker or mental health professional, that is something obviously where we would definitely have to possibly hire someone, that outside new position, and that'll be covered through the proposal. But to have that joint team working and responding to these types of situations out and about in the community.
So who would pay for the caseworker, under whose budget?
Yeah, we'd have to figure out if it's going to come from the PD's budget, fire department, or a community services department with Mrs. Kira Choa.
Okay, thank you.
You're welcome.
Okay, I just have a couple of things. I want to thank everybody for the conversation. Thank you, Chief, for being here. You had mentioned when you use things like tasers and your beanbag shotgun, and you might have mentioned a couple other things. All of that gets documented and it's reviewed quarterly. Is that often enough, do you find?
Madam Chair, committee members, yeah, I do believe it's enough time to review everything. Not just because, example here, if Andrew Padilla were to go use his taser right now, my first line supervisor would document the incident. And just because that first line supervisor documents the incident doesn't mean that 2 months goes by and then that group of police lieutenants review it along with the other specialists that help them out. At that point, it goes up the chain of command. It would go up to the next level of supervision, which would be like a police lieutenant, and then eventually the captain and the deputy chief of police, or Deputy Chief Paul Joy. So there's not just that first line supervisor that, although they document it and they review it, there's still at least 2-3 sets of eyes on top of them that review to see, was every step followed, or is anything need to be flagged, or although that first line supervisor is saying it's within policy, that next line supervisor or captain or deputy chief would say, there's no way this is in policy and we feel this is outside of that policy. At that point, we can pull that one from the pending review pile or that quarterly review pile. And that's something that we need to review immediately and launch some type of internal affairs investigation.
So I guess if you're reviewing quarterly, you could kind of see trends maybe in how those particular items are used. If you're looking at them every 3 to 4 months.
Madam Chair, that is correct. If we, through that chain of command review, if they were to identify some type of new trend, or this one individual officer is continually doing something wrong, either using that force or tool improperly, then at that point we would say, hey, call a timeout. This is what needs to be done. That individual officer or group of officers, or maybe just people aren't grasping the updated policies, techniques, guidelines, and we need to call a timeout and say, at this point, here's the refresher training. We need to get this information out there as soon as possible because we're seeing something is going wrong altogether.
Okay, and can you briefly talk about the Public Safety Committee and how you interface with them and what kinds of advice they give you? It's a citizen committee, correct?
Madam Chair, that is correct. It's chaired by Councilor Rivera, and then it has a handful of citizen members at this point. They do review, like I said, they make recommendations. They don't have that official approval, just like the Finance Committee or the Quality Life. They don't have that authority. It's more just, hey, here's a review and updates. We provide them updates on how the police department's doing, how the fire department's doing, how the regional emergency communications department is doing, or the dispatch center. They have the representatives or director Vanessa Marquez will also attend and give her update and review of everything. But we provide an update on how we're doing on staffing wise, how many vacancies we have. We highlight the great work of the men and women of the police department, cases of the month. They did a great job and handled this type of situation. We acknowledge and recognize the great work that our officers are doing. If we do have any upcoming operations like the Spring Blitz or Fall Blitz or the Operation Downtown Focus, we give them updates on how that we've dedicated 4 officers to the plaza area and this is what they're doing. Or we have an upcoming traffic safety blitz and they're going to be focusing on loud mufflers and exhibition driving or exhibition of speed there. In and around the plaza and any other neighborhoods within the city of Santa Fe that need that type of focus, we update them with those type of situations and stats.
Okay, thank you. And just my last question, and it's actually more of an opportunity for you. You bring up the dispatch center, and I think we call it the RECC, is that right?
That is correct, Madam Chair. You got the acronym correct.
Okay, good. If you might just address, because we have gotten a lot of emails about the response time to India Palace, and my understanding is that the response time, maybe you can just kind of explain to the public and the press and anybody watching and to the counselors, if they don't know, what happened there in terms of, the way that call got ranked and then how quickly your officers responded once they were dispatched.
Yeah, Madam Chair, committee members, just like with any situation or normal day for service that's happening right now, depending on what shift and how many available resources or officers we have out on that individual shift, depending on how many priority one calls. A priority one call is like a domestic violence situation in progress, a robbery in progress. Is there a burglary in progress? So it's always preservation of life over property. So if someone will report that they lost their wallet or they had their pedal bike stolen 1 day ago or 1 week ago, those are lower priority calls. So those are the calls that are going to pend. It's up to the dispatcher and the officers to respond to those priority one calls, a crash with injuries. Officers are always going to have to respond to those types of calls for service first. And a majority of those calls require not just one officer to respond to. If it's a 911 call, 2 officers have to respond to. If it's a domestic violence situation, 2 officers have to respond to. So on each individual shift, where it could be 8 officers for the entire city working for swing shift in the hours that we're working right now, if all of them are busy, tied up on calls, and one call lasts 20 minutes or 30 minutes or 3 hours, or it's a critical incident like what happened over at Big R the other day, all those officers are going to be dealing with that situation. So all of those other lower priority calls where there's criminal damage to property, or someone broke into my home, it's not actively happening right now, even though those hateful words and hate crime was, as the way it's being categorized at this time, it was still damage to property. And that day, for that day shift team, all the officers were very busy. And yes, that supervisor of that shift was notified of all the pending calls for service, but there were other higher priority calls for service pending, and the officers had to respond to those calls for service first. So yes, that unfortunate incident for India Palace did pen for 3 hours. And yes, anyone's going to be upset of why it took so long. The police department currently has 22 police officer vacancies right now. Although we've hired 12 cadets in the last year, like I said, with the COVID crisis, the 3 cadets that were in the law enforcement academy due to COVID, they called a timeout on that. And they're going to be resuming the academy now in a couple weeks. The other 9 cadets that we hired maybe about 2 months ago, the Law Enforcement Academy hasn't reestablished their schedule. They were originally scheduled to go to the academy now in July. Who knows when that updated schedule will come out from the Law Enforcement Academy for those 9 cadets to go to the next academy. If that's going to be in October, November, that's me wishful thinking, or are they going to be pushed back till January, February, March of 2021? So what I'm trying to get at is, although we have 22 vacancies on paper right now vacant, we have an additional 12 officers who aren't fully trained and they're not out on the streets all by themselves. So in all reality, that's an additional 34 officers that aren't out and about in the field. And then on top of that, you may have an officer on a shift that calls in sick. They might be in some type of advanced training. They might be out in some type of family medical leave. Did they have a birth of a child? Did they have some type of injury to themselves on duty or off duty? All that has to be taken into consideration. So it's not like the police department doesn't care about certain types of situations or calls for service. We take every calls for service seriously. But when those calls for service supersede the manpower the allocation that we have, that's what's going to slow things down. So it's unfortunate that calls for service took 3 hours for us to respond to. And I'm not trying to sugarcoat anything, but that is a common occurrence based upon the calls for service that our officers respond to on a daily basis, where situations like that do happen on a daily basis. As of today, or even happening right now, someone could have called a police department to say someone broke into their home and stole all their valuables. And that call for service example could have been called in at 1 p.m. today. And just because the officers are busy through day shift and now into swing shift, that call could be pending right now for possibly 6 to 7 hours.
Okay, thank you. I think it's important for to understand, I guess, the push and the pull of what you all deal with on a daily basis. Again, thank you everyone for your questions, your thoughts. Thank you, Chief, for being here. Thank you for your service. Please extend our thanks to your officers, and hope you'll come back, and maybe we can discuss some other things that are of interest to the community in this committee. So thank you for being here. With that, I want to move on to matters from staff. Jennifer, anything?
I don't have anything at this time. Thank you.
Okay, matters from the committee? All right, matters from the chair. I would just let you all know our next meeting is July 15th. And we will get an agenda out, I think next week, something like that. So thank you all, really appreciate it. Councilor Rivera, you look like you want to say something.
I just wanted to wish Councilor Villarreal a happy birthday and hope she has a great July 4th.
Thank you, compa.
Fun day to have a birthday. All right, happy birthday. Anybody else? Great, thank you all. Have a great night.
Bye, everyone.